모든 국민은 인간으로서의 존엄과 가치를 가지며 행복을 추구할 권리를 가진다. 국가는 개인이 가지는 불가침의 기본적 인권을 확인하고 이를 보장할 의무를 진다. 대한민국 사법부는 국민의 기본적 인권과 정당한 권리 행사를 보장하고 이를 통해 자유, 평등, 정의를 실현할 사명을 국민으로부터 엄숙히 부여받았습니다. 격동의 역사 속에서도 대한민국 사법부는 국민의 자유와 권리를 최대한 보장하고 소수자와 약자의 권리를 보호하는 최후의 보루로서 그 소임을 다하여 왔습니다. 대한민국 미래 사법의 청사진을 제시하기 위하여 2014년 사법정책연구원이 출범하였습니다. 대한민국 사법부의 명실상부한 싱크탱크 사법정책연구원. 사법정책연구원은 현실과 예상, 실무와 이론을 아우르는 체계적인 연구를 통하여 미래의 사법부가 추구해야 할 바람직한 모습을 제시하고 있습니다. 국내를 넘어 세계를 향해 도약하는 사법정책연구원.
사법정책연구원은 대한민국 사법부의 싱크탱크입니다. 국제적 기준에 맞추어 우리 사법의 미래를 구상하고 사법제도의 개선을 위하여 노력하고 있습니다.
대한민국 사법부는 투명한 절차와 공정한 결과를 통해 국민이 수긍하고 감동하는 좋은 재판을 해나갈 것입니다. 이를 위해 사법정책연구원은 새 사회의 흐름에 부응하는 새로운 사법정책과 제도를 연구함으로써 국제적 수준에 걸맞은 사법정책을 제시하겠습니다. 미래를 여는 사법정책연구원.
Welcome back, everyone. I hope you enjoyed your lunch. To kick off the session 3, I would like to invite the Honorable Secretary General of HCCH, Dr. Christoph Bernasconi, to deliver his greeting speech online. Distinguished guests, please join me in welcoming him with a big round of applause.
Thank you very much for these kind words. I hope you can hear me. Distinguished moderator, Professor Suk, so nice to see you again. Distinguished speakers, Justice David Goddard, I guess in Wellington, Deputy Secretary General, Professor Anna Veneziano, I presume in Rome, and Presiding Judge Jeong Jang in Seoul. Equally nice to see you all again. Dear participants, to everyone tuning in around the world, a heartfelt early good morning to you all from dark The Hague, and a good afternoon or good evening, depending on where in the world you are joining us from. Since it is the first time that I'm taking the floor during this conference, I'll start with a note of thanks, if you'll indulge me. First of all, to the Judicial Policy Research Institute for its wonderful initiative, and to our sister organizations and co-hosts, Ancitral and Unidroit. Heartfelt appreciations go to the entire JPRI Conference Secretariat for their invaluable assistance in making this event possible, especially in the current global circumstances. Special gratitude to my current and former permanent bureau colleagues involved in the conference, judges Yun-Jung Choi, So-Jing Cho, and Jeong Jung. Last, but certainly not least, a special thanks also to the generous sponsors of this conference, the Korean Bar Association, Korea International Trade Law Association, Korea Private International Law Association, Association of Korean Judges for International Trade Law Studies. As always, it is a true and real pleasure to participate in events hosted by the Korean authorities. The Republic of Korea has been and continues to be a strong supporter of the work of the HCCH ever since it became a member of the organization in 1997. It is currently party to 4 HCCH conventions, the Apostille, Service, Evidence, and Child Abduction Conventions, and it has signed the Adoption Convention. The Republic of Korea, I'm very pleased to say, has also been a strong supporter of and has been actively involved in the work that led to our newest convention, the HCCH 2019 Judgments Convention, which of course brings us to the topic of this session. The Judgments Convention provides a much needed and long awaited piece of the puzzle in the field of cross-border dispute resolution. For the first time, a large representative number of states from around the world has developed and by consensus agreed upon a convention that will facilitate the circulation of civil or commercial judgments at the global level. The convention establishes a common framework of rules for the recognition and enforcement of foreign judgments in civil or commercial matters, providing legal certainty and predictability for those operating in cross-border situations. Importantly, the Judgments Convention sets up a floor, minimum standards, rather than a ceiling for recognition and enforcement. So states that have liberal rules on recognition and enforcement can, of course, continue to apply these rules and go beyond what is required by the Convention. The project which eventually led to this convention started in 1992. Along the way, the project also brought us the 2005 Choice of Court Convention, which entered into force on the 1st of October 2015. 31 states and the European Union are currently bound by this convention. 4 signatories have also started to join the convention by way of this signature, including the US and China. And we do, of course, encourage our Korean friends and other states from around the world to follow suit. All this to say, the adoption of the 2019 convention was the culmination of a long voyage, journey, longer than we had perhaps anticipated when we first set sail. We weathered some stormy seas, but we were very fortunate to have as our trusty captain, Justice David Goddard. I don't know if you can see this on my little souvenir here, a picture from the negotiations. Justice Goddard, who guided us safely to shore. I'm very pleased to leave you in the very capable hands and the authoritative mind of Justice Goddard to present the intricacies of the convention later on in this session. An important aspect of the convention is that it does not cover the actual enforcement mechanism under domestic law, And I think the question of actual enforcement will be elaborated upon by my dear tripartite colleague, UNIDROIT Deputy Secretary General, Professor Anna Veneziano. And of course, the effectiveness of the Convention relies upon its widespread acceptance by the international community. And the current signals and feedback are indeed encouraging. But its success, of course, also relies on its practical application by judges in the courts of contracting parties. I hope that Judge Jiongjiang will be able to shed further light on where the Convention fits into the overall picture of recognition and enforcement of foreign judges in Korean courts. I say all this not knowing precisely what each of the panelists will be saying today, so I should probably leave that to them. But before I do, one final thought from me. As I have mentioned on a number of occasions, the Judgments Convention has the potential to be a true game changer for cross-border dispute resolution and private international law more broadly. It holds a great deal of promise for individuals and businesses alike, facilitating cross-border trade and commerce and investment and ultimately access to justice for all. And now, without further ado, I give the floor, the screen, back to Professor Suk, and I look forward to the interesting discussions that follow. Thank you.
Thank you, Dr. Bernasconi. Please give him a round of big applause once again. Now, we will commence the session 3, and our topic for this session is recognition and enforcement of foreign judgments. It is a great honor for me to introduce the moderator of this session. The moderator of this session is Professor Kwang Hyun-seok, the professor of Seoul National University School of Law. Professor Seok graduated from Seoul National University in 1979 and received his master's degree in law from Arvid Ludwig University of Freiburg in Germany in 1991. He earned the degree of Doctor of Laws from Seoul National University in 2000. He formerly worked as an attorney at law at Kim and Jong for 15 years. He worked as a professor of Hanyang University School of Law, and he has been a professor of Seoul National University School of Law since 2007. Professor Seok is widely acknowledged as a prominent scholar who has been leading the field of international commercial law. Now, I would like to turn over the session to Professor Seok.
Well, thank you very much, Dr. Kim. First of all, I would like to express my thanks to Secretary General, Dr. Bernasconi, and the organizers of this international conference. I used to attend several meetings of the Hague Conference. So for that purpose, I went to The Hague several times. And I also attended several meetings of the UNCITRAL. For that purpose, I went to Vienna and New York. I went to Vienna and New York together with Justice Yoon Sung-geun, who is sitting just in front of me. And I once visited Rome to attend a conference of the UNIDROIT when UNIDROIT was preparing a so-called Geneva Securities Convention. So, as you understand, these three organizations are the most important organizations involved in drafting international instruments on international commercial law and private law. And in order to participate in meetings of these organizations, I had to visit several places in the world. But now, here today, we have a conference co-hosted by JRTI and Hague Conference, UNCITRAL, and UNIDROIT. So it's really amazing to myself. And on top of that, whenever I made an observation or intervention in The Hague or Vienna and New York or Rome, I had a wish. If I could speak Korean I could make a perfect, more sophisticated intervention in a very much refined way. Finally, today, I now have the opportunity to express my views in Korean perfectly, but unfortunately, my role is limited to just serve just as a moderator, and the discussion will be held in a different session. So what I can do in this session is to just introduce distinguished speakers. So in a sense, it's a pity. Anyway, Korean is one of the governing languages. This morning you heard much about governing law, but now I'm talking about governing language. Today's governing language is English and Korean. So I would like to, from now on, I would like to speak Korean. If you read. So thank you very much for your support. 자, 감사합니다.
Well, thank you again. So as I just mentioned, so many of you would be tired of listening to English, and so I've listened to our simultaneous interpreters this morning, and I thought that they speak better English than me. So I decided to speak in Korean. So, as I mentioned earlier, there's not much for me to do. My role is quite limited as I am a moderator for this session. And again, the topic we'll be addressing is recognition and enforcement of foreign judgments. And in international private law, foreign judgments and recognition and enforcement of it is very important. So just before, from HCCH, Mr. Bernasconi delivered a well-thought-out speech. So Judgment Convention was adopted last year, and July this year, JPRI and also my institution had a joint conference. So this afternoon we will be, and also in that conference afternoon, we talked about this very topic. And 2005 jurisdiction convention was also dealt with in one of our meetings as well, which is the topic that Mr. Godard will be talking about. So again, through this conference and through various occasions, we in Korea have been making a lot of efforts so that this jurisdiction and also judgment convention can be widely adopted. So I'd like to thank all the people who joined in that effort. So anyways, in this session, we will be listening to Mr. David Godard from New Zealand. He is going to talk to us about these two conventions. And then we're going to also invite Madam Anna Veneziano, Deputy Secretary General of UNITRA. She's going to talk about a slightly different topic. She's going to talk about UNCITRAL and UNITRA's roles in these recognition and enforcement issues. And finally, I will be inviting over Presiding Judge Chang. So with that, I would like to introduce to you Mr. Godard. You can look at his CV in the program book, but what's important is that he is currently a justice in New Zealand Court of Appeal, and he's also QC. And in 2003, in HCCH diplomatic meeting, when the jurisdiction convention was being adopted, he was vice chair. And last year, when Judgment Convention was being adopted, he was also serving as the chair of the diplomatic meeting. So he indeed played a very important role in these two conventions. So without further ado, I would like to invite over Justice Godard to share with us his insights on these two very conventions. I think that it will be very useful.
You ready?
I am. I hope you can hear me.
Oh, thank you very much. Now you have the floor.
Thank you very much, Professor Sook. Distinguished moderator, distinguished participants, colleagues, friends, greetings to you all from a sunny Wellington evening. I'm very sorry not to be able to be with you in Seoul today in the extraordinary circumstances that affect all of our ability to travel and meet together but I am delighted to be able to join you virtually at this very impressive conference. As I say, my only regret is that I cannot be there in person to meet you all and to make the most of the excellent lineup of speakers and discussions that you have planned. I've been asked to talk about the HCCH Choice of Court and Judgments Conventions. I had the great privilege of being involved in much of the journey that our Secretary General, Christophe, my dear friend Christophe, who has a long-standing love of metaphors, referred to when it began, when I first got involved in the 1990s. My hair was not grey at all, and now it is. But over the 2 decades that I've been working on this project with Christophe and others, although my hair has gone grey, we have, I think, achieved a great deal, and it's my very great pleasure to talk a little bit about the project today. It's a pleasure and it's an important task, because I believe that, as Christophe Bernasconi said, these are very significant instruments for legal cooperation globally, and in particular, our focus, I think, in the Asia-Pacific region. I think they will add significantly to the many other layers of cooperation between Asia-Pacific states. So what I'm going to do in the next 15 minutes or so is to provide a whirlwind tour of the 2 instruments, a tour facilitated by Christophe stealing some of my best lines, and I hope not hindered too much in terms of my credibility by his display of the photo of me wearing the captain's hat, which I would like to point out he chose and gave to me in the context of our negotiations. I'm going to attempt to share my screen. I should in principle be able to do this. Let me see if I can put up my PowerPoints. Here we go. I hope you can now see my slides. It looks like you can. So what I'm going to talk about is an overview, really, of the Judgments Project and its 2 key outputs, its 2 key products, the Choice of Court Convention and the Judgments Convention. Before talking about how they work, I think it's important to pause and ask why they matter. Why did we spend more than 20 years developing these instruments? What do these conventions add to our respective national laws? For we all have national laws in relation to recognition of judgments and enforcement of judgments. Recognition of their preclusive effect, of the fact that they finally determine certain claims as between the parties, and in certain cases enforcement of the money awards or other remedies for which they provide. What's the point? Well, as I say, as a brief summary of my objectives, and here I am echoing Christophe's words, 2 fundamental objectives of these instruments: enhancing access to justice and facilitating cross-border trade and investment by reducing the risks and costs associated with cross-border dealings. The instruments pursue these objectives in 6 main ways. First, and most obviously, but very importantly, judgments to which the conventions apply will be recognised and enforced in all contracting states. That enhances practical access to justice, because when parties go to court, they don't go to court in order to end up with a piece of paper with the court seal on it. They go to court to achieve substantive outcomes that are effective. And in this increasingly interconnected world, with extensive trade, investment, and with certain recent exceptions, movement of people across borders, it's increasingly necessary for judgments to be effective in more than one country in order for them to be practically effective, in order to achieve practical access to justice. Second, these instruments will in many cases avoid the need for duplicative proceedings, substantive proceedings in more than one country in order to achieve that practical justice. Third, and very importantly, both the Choice of Court Convention and the Judgments Convention, as I'll go on to explain, enhance the effectiveness of provisions in cross-border agreements that prescribe where disputes must or may be resolved. That enhances predictability and reduces risk at two key points in time. First, when the agreement is entered into, and second, if and when a dispute arises. Fourth, the instruments significantly improve the accessibility of the law concerning recognition and enforcement of judgments and the certainty and clarity of that law. They're not comprehensive, as Christoph said. They don't attempt to exclusively deal with this topic. But in the area where they operate, they make it much easier both to ascertain one's own rules in relation to inward recognition and enforcement, and critically, to be able to predict what rules will be applied in other contracting states if it's necessary to seek recognition and enforcement there. Linked to that, fifth, the conventions will facilitate giving advice on recognition and enforcement. It's today almost invariably necessary to seek specialist advice in relation to the recognition and enforcement of a judgment from lawyers in each of the states in which one might want to obtain recognition to enforce the judgment. If you are in a contracting state, if you have a judgment from a contracting state, and the state in which you hope to have that judgment recognized and enforced is another contracting state, then in many cases it will be possible to predict with a high degree of confidence that the judgment will indeed be recognized and enforced. And sixth, and very importantly, these instruments will assist parties to make initial informed decisions on where to bring proceedings. The Choice of Court Convention contains rules on this subject, which I'll come to in a moment. Judgments doesn't, but nonetheless, the question of where a judgment, where proceedings should be brought in order to enable the resulting judgment to be enforced is always an important factor in deciding where to initiate proceedings. And if that is more readily ascertained, then parties will be much better placed to make informed decisions about where their disputes can best be pursued. So how did we end up where we were? Well, there was an initial very ambitious proposal made, in fact, by the United States in 1992 for a mixed convention which would deal both with questions of jurisdiction, authorizing the exercise of jurisdiction in some cases, prohibiting it in others, with a grey list in the middle, and the enforcement of judgments, where the judgment was given by a court that was able to exercise whitelist jurisdiction. This was a very ambitious project, and it raised a number of difficult issues that ultimately were not capable of being solved on a global basis, at least at that time. And so from 2001 onwards, we took a more focused approach in which we decided to work not with a view to solving everything all at once, but out from a central core. We decided that we would start with the least controversial, but still practically important cases, and then, having dealt with those, see if we could take our work further. We focused our work on jurisdiction and enforcement of judgments, recognition and enforcement of judgments, in cases where parties have entered into an exclusive choice of court agreement. And in 2005, we were able to complete the Choice of Court Convention, which, as Christoph Bernasconi said a moment ago, has been in force since 2015. We then turned our attention to the next set of issues that we felt were worthwhile and achievable, and focused on recognition and enforcement of judgments. That work was completed at the diplomatic session of the Hague Conference, the HCCH, which I had the enormous privilege of chairing in 2019. And I hope that before long we will be able to announce a date on which that too has come into force. Briefly then, the Choice of Court Convention. This convention, as I said a moment ago, applies to exclusive choice of court agreements that designate a court or courts of a contracting state as the exclusive forum in which the parties' disputes are to be resolved. The agreement must be in writing or an electronic equivalent, using the familiar UNCITRAL model law on electronic commerce formulation. And this is an important point for common law countries, not I think so much for civil law countries. The convention introduces a presumption that a choice is exclusive unless the agreement provides otherwise. This reverses what is seen as the usual default rule in a number of common law jurisdictions. It applies to civil and commercial matters. It's effectively a court-based equivalent of the widely ratified and very important New York Convention on Arbitration. It doesn't apply to consumer or employment disputes. It's sometimes described as a B2B convention. That's not quite right, of course, because there are many public bodies, foundations, other entities that are not businesses, as we normally think of them, whose contracts are within the scope of the convention. But consumer transactions are excluded, employment contracts and employment disputes are excluded. There are certain other exclusions in the time available. I won't go through them. They're easily found in the instrument, and they're explained in the very helpful explanatory report prepared in relation to that convention. I should say that both the Choice of Court Convention and the Judgments Convention are accompanied by excellent explanatory reports prepared by rapporteurs who participated in negotiations and brought their significant learning and experience to bear in explaining how these instruments work. If you do encounter questions in relation to these instruments, I would encourage you to refer to the explanatory reports which are found on the HCCH website. So moving on, the basic architecture of the Choice of Court Convention. The Choice of Court Convention does three fundamental things. First, the chosen court must decide the dispute, with one very narrow exception where the dispute has absolutely no connection with the chosen court, the state of the chosen court, apart from the choice. The chosen court must decide the dispute. It can't decline to exercise its jurisdiction. So the parties have a high level of certainty that if they choose a court, their disputes will indeed be decided in that court, in the chosen state. Second, and critically, courts and contracting states other than the chosen state must give way to the chosen court. They must decline to exercise jurisdiction unless the chosen court has itself, for whatever reason, declined to hear the dispute, a scenario which is most unlikely in practice. So the chosen court must decide the dispute. Any other court must, at the request of a party, decline to hear the dispute. And third, the third piece of the puzzle, the judgment of the chosen court must be recognised and enforced in any other contracting state. The convention applies to a wide range of final judgments. It doesn't apply to interim relief. It doesn't apply to procedural steps along the way. It applies to final judgments. But it does apply not only to money judgments, which are widely recognised and enforced today, but also to non-money judgments, judgments awarding specific performance, for example, or an injunction restraining a contracting party from breaching the contract. Now, we're all familiar with enforcing arbitral awards that contain relief of that kind, but it's much less common worldwide to find provision for the enforcement of non-money judgments. And the Convention in this respect is a very important and very welcome addition in a world where a great deal of wealth, a great deal of value is represented by confidential information, by know-how, by other matters that are best protected by orders for specific performance or by injunctive relief. The Convention sets out limited grounds for refusing recognition and enforcement. I'll go through those briefly when I come to the Judgments Convention. And critically, very importantly, it prohibits review on the merits of the judgment of the chosen court. Parties chose the court, parties have got an answer from their chosen court. That decision is not reviewed on the merits in a state in which recognition or enforcement is sought. Importantly, as Christophe Bernasconi said, I did say he'd stolen many of my best lines, the Convention doesn't restrict or limit in any way the recognition or enforcement of judgments under national law. So nothing in the instrument prevents recognition or enforcement of judgments given by a chosen court. In other scenarios, it doesn't touch on recognition or enforcement of other judgments, but it does set a very important floor for recognition and enforcement of decisions given by a chosen court. What then of the Judgments Convention? Well, some of its key features in this whirlwind tour. First, it provides for recognition and enforcement of judgments in civil or commercial matters. That same broad scope as choice of court, civil or commercial matters, not matters of public law, not matters of administrative law. It doesn't contain provisions governing direct jurisdiction. It doesn't contain provisions that regulate parallel proceedings in more than one state. It's concerned solely with the position after a judgment has been obtained in a contracting state. And it applies again to final judgments, including non-money judgments. That's as important in this context as it was in choice of court. It includes default judgments. I should probably have said that in relation to choice of court, because that's true there. A party with no defence can't improve their position by failing to turn up if the judgment is otherwise within the scope of the relevant convention. And it excludes interim measures of protection, again, as with choice of court. Critically, it's facilitative. It sets a floor for recognition and enforcement. National law can provide for more extensive recognition and enforcement, and there are many bilateral arrangements, for example, the Australia-New Zealand Trans-Tasman Proceedings regime, and regional arrangements in many parts of the world that provide for more far-reaching recognition and enforcement of judgments. The one exception to the ability of national law to provide for more extensive recognition and enforcement is found in Article 6. There's a prohibition on enforcement under the Convention or national law of judgments concerning rights in rem in immovable property, unless the property is situated in the state of origin, the state where the judgment was given. This is a limit found in the national law of many states in any event, but it was seen as so important and was so critical to the willingness of some states to adopt the instrument that it's expressly spelled out in the Judgments Convention. Exclusions from scope. Well, a number of matters are excluded from scope, including various matters that are addressed by other international regimes, for example, maintenance of children and other family members, insolvency, carriage of passengers and goods, and certain maritime matters. Certain matters of particular sensitivity where there was real policy concern about judgments travelling without additional controls, defamation, privacy, and antitrust competition law. In the competition space, there's a very carefully crafted exception to the exception that brings judgments in relation against participants in hardcore cartels back into scope. And then, and this is I think my only real regret in relation to the Judgments Convention, there ended up, after much discussion, being an exclusion from scope of intellectual property matters. It just proved too hard for us to reach a consensus on the circumstances in which intellectual property judgments could circulate. I'm confident that we can get there on that over time. I think this is a future project for the HCCH, perhaps working with WIPO on this. But for now, IP matters sit outside the instrument. Convention doesn't apply to arbitration and related proceedings. I won't go through the details of that in the time available, but basically it does not affect the law in relation to stay of proceedings in favour of an arbitral tribunal or national law on refusing recognition and enforcement of a judgment where the proceedings in the court of origin were inconsistent with an arbitration agreement. And it, of course, does not govern the recognition and enforcement of arbitral awards. That is, for the most part, governed by the New York Convention, supplemented by national law. When will a judgment be recognised or enforced? Well, of course, it has to be in a civil or commercial matter. And then there are various jurisdictional filters, also sometimes referred to as indirect grounds of jurisdiction, that must be present for a judgment to be capable of recognition or enforcement. Now, critically, it does not matter what basis the state of origin exercised its jurisdiction on, or indeed whether it ever expressly considered the basis on which it was exercising jurisdiction. The question is whether the court of origin could have exercised jurisdiction on one or more of these grounds, where the person against whom recognition or enforcement is sought was habitually resident in the state of origin. It's a very familiar ground. Where the defendant had a branch or other establishment in the state of origin and the claim relates to the activities of that branch or establishment. Submission, very familiar, including submission by counterclaiming within the scope of the issues dealt with by the counterclaim. These grounds, these submission grounds, are modified in relation to enforcement against a consumer or an employee. Should perhaps have said that judgments does extend to consumer disputes, does extend to employment disputes, and consumers and employees can take full advantage of all the grounds for recognition or enforcement in the Convention, but those grounds are modified to protect the more vulnerable party where recognition or enforcement is sought against a consumer, against an employee. Other grounds, and I can do no more than zip through them very fast, where the state of origin is the place where a contractual obligation was performed or ought to have been performed. There's a defence inspired largely by constitutional concerns of the United States delegation in relation to proper exercise of jurisdiction, if, despite the fact that the contract provided for performance in a particular state, there's no purposeful and substantial connection between the defendant and that state. Non-contractual claims in respect of death, personal injury, damage to or loss of tangible property, where the act or omission directly causing harm occurred in the state of origin. And then importantly, very importantly, in terms of those enhanced certainty of cross-border trade issues that I mentioned earlier, objectives that I mentioned earlier, the designation of the court of origin in a non-exclusive choice of court agreement, or the designation of the court of origin in a trust instrument, and then certain positive rules in relation to judgments on immovable property, where the judgment's rendered by the state of origin. The other key features of the Judgments Convention: limited grounds for refusal of recognition and enforcement. These are very similar to, but not exactly identical to those in choice of court. There are a few adjustments made because of differences in subject matter, differences in scope. And again, many of these will be very familiar to you from the national laws of many countries that you'll have encountered. Absence of adequate notice of the proceedings, fraud, the judgments inconsistent with public policy or fundamental principles of procedural fairness in the state addressed. Importantly, provisions which again protect the integrity of choice of court provisions that to some extent limit where a dispute can be pursued. if the proceedings in the court of origin were contrary to an agreement or a designation in a trust instrument which provided for the dispute to be determined in another court, then the court addressed can decline recognition and enforcement. Then there are other grounds in relation to conflicting judgments given in or recognised in the state addressed, and a novel but potentially useful ground where there were proceedings in the state addressed before proceedings were commenced in the court of origin. So the court, the state addressed, the court of that state was first seized, and there's a close connection between the dispute and that state. Again, as with choice of court, no review on the merits. If the other criteria are met, the judgment must be recognised and enforced. The court addressed doesn't engage with the merits of the dispute, and certain safeguard provisions, safety valve provisions for exceptional cases that were a cause of concern to various participants, in some cases all participants in this matter. I will mention the last of these because it's very important. Choice of court is an open convention. If a state becomes a contracting state, then the choice of court convention will apply as between it and all other contracting states, all other parties to that instrument. But with judgments, because the parties haven't chosen the court, and because some states identified potential concerns about recognition or enforcement of judgments from states where there are systemic issues of fair process, there's a opt-out regime so that when a state becomes a party to the instrument, it can opt out of treaty relations with an existing contracting state. Conversely, the existing contracting states can, when a new state becomes a party, give a notice opting out of treaty relationships with that state. Now, I don't think anyone envisages this power to opt out will be exercised much, if at all, but what it does is ensure that by becoming a party to the Judgments Convention, a state is not committing to recognise and enforce judgments from a state about whose judgments there are systemic concerns. That's a very important reassurance that many governments and many judges I spoke to over the years were concerned to see that we addressed. Finally, the relationship between the two instruments, they're complementary, they're sister conventions. The expectation is that states will become parties to both and they'll operate in tandem. The Judgments Convention, because it deals with non-exclusive choice of court agreements, overlaps with an optional declaration regime about non-exclusive choice of court agreements in the Choice of Court Convention. It's a far superior set of rules in relation to that particular issue, and likely, I think, to supersede the optional declaration regime, which has never been used to date. The choice of court, non-exclusive choice of court provisions in judgments are incredibly important in relation to financial transactions. Many financial transactions contain non-exclusive choice of court provisions. Choice of court convention will not address the risks and challenges associated with cross-border enforcement in relation to such transactions. Judgments will. So it's also very important in the trade, investment, contractual context. I'm confident that these instruments can operate together well to significantly advance the goals of enhancing access to justice and facilitating cross-border trade and investment. But of course, the critical requirement for this to happen is that they need to be widely ratified. I see no reason why they shouldn't be, and I see many reasons why they should, and I'm very hopeful that that will happen, including with significant support from countries in our region. Thank you very much.
Thank you, Justice Goddard, for your excellent but brief and very informative presentation on the two conventions of the Hague Conference, the Choice of Court Convention and Judgment Convention. After making my speech in Korean, I learned from my neighbor, Judge Zhang, that simultaneous English translation is not offered on internet. If that's the case, then I should apologize. So I have to come back to English, my poor English. Anyway, now we can better understand the choice of court convention and the judgment convention. And I understand that the Korean government, and including Korean judicature, are now considering whether Korea should be a party to these two conventions. So I strongly suggest that all the audience here would do further research on these two conventions and try to spread the awareness about this convention to Korean experts dealing with the international transactions and international commercial litigations. And now let's move on to the next speaker. The next speaker is Anna Veneziano. In fact, she made a presentation this morning on the WINIDRA principles of international commercial contracts. Now, she will make a presentation on the WINIDRA's work on civil procedure, with a focus on ALI, American Law Institute, WINIDRA principles, and the ELI and WINIDRA principles, best practices on enforcement project. Compared with the Hague Conventions and the UNCITRAL projects, in my view, the UNIDRA's work on civil procedure is not widely known in Korea, especially Korean lawyers. So I think this is a wonderful opportunity for us to familiarize ourselves with the recent work, UNIDRA's work on civil procedure. So, Anna Veneziano, I think you have some basic information about her, and she is now Deputy Secretary General of WINIDRA, and she is also a professor on comparative law in Italy, and she has much experience on WINIDRA project. I'm wondering whether she is ready. No, this is a pre-recorded presentation.
Ladies and gentlemen, good morning, good afternoon, and good evening again. I apologize to the distinguished chair and my fellow panelists, as well as the audience, for intervening yet again through a video recording due to the adverse time zone difference. But as I said before, I will be present remotely but live soon in the next panel for the discussion. As you see from the title, I will present UNIDRA's work in the field of civil procedure, and in particular the ALI UNIDRA principles, the ALI UNIDRA rules, model European rules of civil procedure, and a new project, the best practices on enforcement. But before addressing the single instruments, I would like to say something about the general aims of the work of UNIDRA in this particular area, which started actually with the ALI UNIDRA principles approved in 2004. Now, one of the important general aims is to assert general standards for the conduct of civil proceedings, which respect a number of important general principles. First of all, they respect fundamental rights, for example, the independence and impartiality of judges, the equality of the parties, the right to representation, the right to receive new notice, the right to be heard, a general principle of transparency, and so on. A second important tenet is the overcome of perceived traditional divides in civil procedural law in general, such as, for example, the divide between a common law or a civil law perspective, adopting what could be called functional best practices. a third important tenet, which we find in all instruments that were developed by UNIDROIT and in the most recent project, is the importance of fostering a cooperative relationship between all actors involved and to improve the effectiveness of procedures, particularly in the commercial sector, in order to facilitate the resolution of disputes, both cross-border and domestic, with a more general positive impact on the well-functioning of the legal system in general. And there is a second important general principle or general aim underlying UNIDROIT's work on civil procedure. The fact that it would be important to fill in the gaps in international law making by developing international guidance instruments. They are not binding instruments, they are all in the form of principles, rules, soft law, guidance that are complementary to already existing instruments developed by UNIDROIT itself or other international organizations, particularly in the field of contract law. Of course, contract law remedies may be disputed and may need enforcement. In the context of secure transactions, we have important instruments developed by UNCITRAL in particular and partly also by UNIDROIT in the field of secured transactions, and this was discussed in the panel before this. So the part which is missing is the part where creditors then need mechanisms and procedures to enforce the rights that they have under their own contracts. And then the whole field of the recognition and enforcement of arbitral awards, judicial decisions and other decisions. These important hard law instruments developed by UNCITRAL and by the HCCH, in particular the New York Convention, the HCCH Judgment Convention, the most recent Singapore Convention, all of those aim at facilitating the recognition of decisions taken abroad, but still when you have to enforce that particular decision or act, you have to rely on the domestic law of the jurisdiction where that act has been recognized and has to be enforced. So one important element is to fill in the gaps in international law making. So I come now to the three instruments: the American Law Institute UNIDROIT Principles of Transnational Civil Procedure, published in 2004, a joint project between the American Law Institute and UNIDROIT, focusing on transnational civil procedure with a particular attention, though not limited to, commercial disputes. And then we have the ELI, UNIDROIT Europeans' Rules of Civil Procedure. This is a project that started in 2014, and they were jointly adopted by the two institutions in 2020, by UNIDROIT most recently in September. It is a joint project between the European Law Institute and UNIDROIT. Those rules were based on the Ali UNIDROIT principles, but they were also based on additional sources, among which, for example, the EU acquis, the work of the HCCH and other intergovernmental bodies, and modern national trends. So they are, of course, important for Europe, but we think that there might be an interesting model for a more detailed civil procedure guidance, let's say, for also for the other parts of the world. And then we have a project, a new project included in the 2020-2022 work program, Best practices on effective enforcement. This project stems from a proposal of the World Bank, and the aim of the project is to produce a guidance document to provide, as the title says, best practices for enforcement procedures, be they judicial or extrajudicial, with particular regard, as we will see, to the use of technology, which of course can solve many issues but can also create additional challenges. Now, I would like to focus first on the Ali UNIDROIT principles. This is a very brief history of those principles, which work was started at the initiative of the American Law Institute, and UNIDROIT joined in 1999. There was a common working group which benefited from a large consultative process, and then they were approved in 2004. So they wanted to represent a global standard which could then subsequently accommodate local adaptations through the formulations of regional rules. And this is exactly what was done then later on in cooperation with the European Law Institute. And the Ali UNIDROIT rules were developed immediately after the development of the Ali UNIDROIT principles as an example of this adaptation to finding more detailed development of the principles, and it was considered to be the basis to continue the work with other regional bodies. Now, what are the basics of the Ali UNIDROIT principles? As I said, it's a guidance document on best practice in transnational commercial litigation. So, of course, it takes into account generally accepted constitutional fundamental values, but it would like to go beyond them to facilitate cross-border resolution of disputes in application of the principles of the principle of due process. Since this was a global instrument, the idea was not to devise detailed rules, but the aim was to draft generally recognized principles of civil procedure to help legal systems move closer together and overcome and reconsider perceived macro divides, such as, for example, that between common law and civil law that we already mentioned. And in this regard, the drafters of those principles found that there was no unitary common law tradition, as there was no unitary civilian tradition, and that on many points the difference could be bridged by adopting a functional best practice, leaving it then to each legal system to decide how to properly implement it. This is why we talk about principles and not detailed rules. And actually, subsequent reforms worldwide in the field of civil procedure have supported this assumption and the tendency to some convergence on issues related to the structure of the proceedings, for example, the role of the different actors, the rules of evidence, the importance of settlements, and so on. Now, this is a very general overview of the Ali UNIDROIT principles of transnational civil procedure. As I said, the idea of those principles was from the start that they could be further adapted to the peculiarities of specific jurisdictions or also specific regions, and this is what happened with the Ali UNIDROIT model rules, because the origin of the project is in a joint workshop held in Vienna between Ali and UNIDROIT, where it was discussed how to develop regional rules based on the Ali UNIDROIT principles and tailored to European legal systems. So there was a very complex architecture of the projects. We are particularly grateful to Eli, of course, and also to the participants in the steering committee, in all the working groups, and in the structure group. We are grateful to the observers, one of them being the HCCH, and to the advisors. The work was organized so that the groups could start working in successive waves, and the results were then discussed by the steering committee of the two organizations. And then they were finally approved by both Eli and UNIDROIT in 2020. Now, why are we talking about these rules here, even if they are regional model rules for Europe? We think that these rules encompass the more detailed civil procedural provisions that are connected to and are seen as an application of the general Ali UNIDROIT principles that might be useful also in contexts other than the European one. The rules are divided into 12 parts. It's a very large body of rules and comments. They cover all aspects of civil proceedings from the inception to appeals, including general principles, parties, collective redress, case management, commencement, proceedings preparatory to a final hearing, service and due notice, access to information and evidence, judgment, res judicata, lis pendens, means of review, and provisional and protective measures. So why did we develop model rules? It was felt by the drafters that it was not the purpose of this instrument to restate existing common practices, nor was it the purpose of the instrument to develop a comprehensive European model code of procedure to be translated as it is into legislations. The idea was to develop a set of model rules that contain varying degrees of detailed regulation, depending on the prevailing degree of convergence and the reasonability and feasibility of future more detailed harmonization. And for example, the rules on evidence are more detailed because there was more convergence, while the rules on means of review or the rules of costs are more general and leave more room to the appreciation of the legislator and also of the adjudicator. And I already talked about the potential addressees, European legislators, courts and judges, academics, but also a potential source of inspiration for analogous harmonization effort in other parts of the world. And I would like here to point to two underlying general principles. The duty of cooperation. Those model rules constitute a significant step towards moving away from the traditional division between adversarial and inquisitorial conceptions of civil procedure by underlining the importance of the duty of cooperation. And the other principle is the principle of proportionality. The increasing importance of this principle can be seen in more recent developments in dispute resolution. The principle of proportionality is then further detailed by subsequent rules, including, for example, the proportionality of sanctions and the proportionality of costs. So coming back to the duty of cooperation, which is really a central duty in the ELI UNIDROIT model rules. This duty of cooperation, and I take it as an example of how these rules are developed, is embodied in general terms in Article 2, cooperation to promote the fair, efficient, and speedy resolution of the dispute. But then, this duty of cooperation is detailed throughout the rules with more specific provisions. For example, the duty of the parties to cooperate in order to resolve the dispute consensually, the duty of the courts to facilitate settlement, and the part 3 of the rules, which embodies the cooperative case management by parties and courts and the part on pleadings, which is a central feature of the rules. So this, of course, we don't have the time to go into the details, but these are the two principles, including the duty of the principle of cooperation and the duty of cooperation and the duty of proportionality, which are omnipresent in the ELI UNIDROIT model rules. Then we come to a new project, and I will conclude my presentation on this new project, Best Practices of Effective Enforcement. This project, as I already said, stems from a proposal of the World Bank, was inserted in UNIDROIT's work program 2020-2022. There was already a preceding project which was, however, reinvigorated by the proposal of the World Bank. And why is this important? Well, first of all, we cannot but say that procedures and mechanisms for effective enforcement of creditors' claims have a fundamental economic and social importance, both in transnational situations as well as in domestic civil proceedings. They are important internally for the well-functioning of the market. They are important also for the social well-being of a jurisdiction, but they are also important in the international arena, for example, for the rating of different debtors and different systems. But there are numerous challenges for enforcement in many jurisdictions, which exist both in developed and developing economies. And there is a lack at present of a comprehensive and sufficiently detailed international instrument providing for guidance for national legislators to overcome such challenges, taking into account efficiency and fairness. So this is why we embarked in this project. The planned scope will cover, will develop a global instrument on best practice for judicial and extrajudicial enforcement proceedings, which means to look at the execution phase of the claim of a creditor against a debtor. We will focus on the enforcement of commercial secured and unsecured debts, though we will be open to cover other claims. We will look at actors, at procedures, at mechanisms, trying to find out whether there are already existing best practices or trying to develop commonly approved best practices in this field. And this is, as I said, perfectly complementary with the work done by sister organizations in the area of the recognition and enforcement of judicial decisions and other decisions. My last slide is about the impact of technology on enforcement proceedings and mechanisms, because we really realize that this is probably one of the most important areas that we will have to consider. How will technology, how does already technology impact on enforcement procedures? First of all, in the electronic service of documents in enforcement proceedings. Secondly, we already see a number of platforms for judicial sales during enforcement proceedings. Technology can be used for the digital tracing of assets. There are also digital mechanisms used for exercising or enforcing remedies of various kinds, like starter interruption devices, blocking of digital accounts, and so on. And then, of course, there is the enforcement on assets which are in themselves digital. So there is a whole area of the enforcement which is strongly impacted by technology, and we think that this technology can play a fundamental role both in developing best practices, but we also have to be aware of the possible challenges of the use of technology. So I would like to conclude this presentation by drawing your attention to our website again. If you would like to find more information, I'm also at your disposal, of course, and I will be delighted to discuss with the panelists later on these topics. And for the time being, I thank you all for your attention.
As you understand, we are already far behind the schedule. But anyway, because she made a presentation by a pre-recorded presentation material, I had no means to control time spent. Anyway, we have the last speaker. Last speaker is Judge Zhang Jiyong, and he is currently a presiding judge at Tongyong branch of Changwon District Court. And in fact, he was seconded to the Hague Conference in 2016, and he spent, I understand that he spent 1 year at the Hague Conference. So he will make a brief, hopefully brief, presentation on the recognition and enforcement of Foreign Judgment Convention, namely the Judgment Convention only. So you have the floor.
Thank you. Good afternoon and good evening and good morning, everyone. I'm very much honored and pleased to be here as a speaker and as a former secondee to the HCCH and as a former researcher at the JPRI. As a judge, being on time is very important for me, and I'd like to give you enough coffee break. So I'm going to make my presentation very short. The first part is the conventions about the cross-border dispute resolutions and the recognition and enforcement of the arbitral award and the mediated settlement or judgment. If you look at the New York Convention, this is the very much famous convention, and it's about the arbitration, and it entered into force in 1959 and has more than 160 state parties. And the first two conventions are from the UN, and the second one is Singapore Convention, which entered into force this year, and it has 6 state parties, including Singapore and Fiji. And Republic of Korea also has signed this convention, but not ratified yet. And it's about the enforcement of mediated settlement from mediation. The last one is Judgment Convention. It's about judgment, also including judicial settlement, and it's about recognition and enforcement of foreign judgment and not yet enforced. Only Ukraine and Uruguay has signed the convention. Let's look at the Judgment Convention. This is a core article, Article 4. It's about the general provisions. The first paragraph is about the obligation of mutual recognition and enforcement. This established the central obligation of the state parties. If you look at the Korean Civil Procedure Act, it's very similar to this Judgment Convention, but the only big difference is about the reciprocity. If we sign this convention, we don't need to look at the reciprocity, which means that the other foreign court would recognize and enforce our decision. And then there should be no review of the marriage. That is very important as well. But I'll skip this part. The decision, the judgment must be effective and enforceable in the state of origin. And what the recognition and enforcement may be postponed or refused if judgment of the subject of the review or the time limit has not expired. Next slide is about the definitions. Article 3, the convention does not define court. Normally we say that the permanent tribunal, which exercises jurisdictional functions at any level, is a court, but there was a draft that was proposal about the definition of the court, but not accepted. The convention is also silent on common courts because this convention does not include the intellectual property. Let's look at the judgment. Judgment is any decision on the merits given by the court. It includes a decree or order, or whatever it is called. The decision on costs also is also included. The Justice David Goddard also touched upon this part, so I'll skip. The judgments by default non-monetary judgments, decision on the costs are decisions, the judgments, but the interim measures of the protection is excluded. And the judicial settlement is also approved, also enforceable in the same manner as a judgment. Yeah, the judgments must be legally valid and operative, and it must have an enforceable power. Okay. But res judicata is not necessary, so it does not require final or the conclusive judgment. Article 7 constitutes about the refusal of the recognition and enforcement. The documents must be notified in sufficient time in a way to enable the defendants to arrange for their defense. If it was notified in a manner incompatible with the fundamental principles of the requested states, it can be refused as well. The fraud can be the grounds for refusal, and if the public policy is also the grounds for the refusal. If it is contrary to the choice of court agreement, or next slide, if it's inconsistent with the judgment given in the requested state or an earlier judgments given in another state, it can be refused as well. There's also the provision about the parallel proceedings in the requested state. Let's look at the consequences of the recognition and enforcement. The recognition means giving effect to the determination of the legal rights and obligation made by the court of origin. But the convention is silent on giving same effects, the doctrine of expansion of effects. I've already mentioned the no review of the merits, so I'll skip this part. The procedure is governed by the court addressed or the state, requested state. But normally it is recognized automatically, and then the enforcement process is a declaration of enforceability, exequatur, or the registration for enforcement. Yeah. So, and the convention says that the court should do it expeditiously. Yeah. So I think I didn't use much time. Thank you for having me, and I hopefully do something more at the discussion time. Thank you.
Thank you, Judge Chang. I'm sorry, I must apologize for not controlling time appropriately. But anyway, thanks to the three presentations made during the third session, now we can better understand the importance of the Hague Conference Conventions, especially the Choice of Court Convention and the Judgment Convention. And we also learned something about the Ali principles and the Eli principles. And I strongly suggest that Korean judges and Korean professors on civil procedure pay more attention to the Ali unilateral principles and the Eli unilateral principles. So because you are very much far behind the schedule, I would like to conclude the third session. But before doing that, I would like to mention my colleague, Professor Lee and Judge Kim. They are seated here, but they did do nothing because they will make their presentation and comments in the following session. So why don't you give a big round of applause to these speakers and future discussants. Thank you very much.
Thank you. It was an inspiring presentation which captured the essence of the issues on the recognition and enforcement of foreign judgments. I think we owe all participants a round of a big applause. This is end of the session 3. For the sake of time, we will take 10-minute coffee break now and reconvene at 4 p.m. I apologize that we will not be able to give you enough time for break. I would like to ask for your kind understanding. Please help yourselves with the refreshments provided at the lobby, and you may also bring the refreshments to your seats. Thank you.
테스트합니다. 하나 둘 셋. 하나 둘. 하나 둘. 테스트합니다. 하나 둘. 하나 둘 셋. 하나 둘 셋. 하나 둘 셋. 하나 둘 셋. 하나 둘 하나 둘. 하나 둘 하나 둘. 하나 둘 셋. 하나 둘 셋. 하나 둘 셋.
Distinguished guests, the comprehensive discussion session will begin shortly, so please enter the conference room and take your seats. 내외 귀빈 여러분, 종합 토론 세션이 곧 시작될 예정이오니 행사장 밖에 계신 분들은 조속히 행사장 안으로 입장해 주시기를 부탁드립니다. 감사합니다. Distinguished guests who are now outside the conference room, please enter the conference room and take your seats. Moderators, speakers, and panelists of this session, please proceed to the stage and be seated in your designated seats. Thank you. 종합토론 세션의 발표자, 사회자, 그리고 토론자 분들은 앞으로 나오셔서 연단에 지정된 좌석에 앉아주시기를 부탁드립니다. 감사합니다.
이거 제가
Now we'll proceed to the comprehensive discussion session, which is the final session of today's conference. Before we start the discussion, it is a great pleasure for me to invite the Honorable Secretary General of UNIDROIT, Professor Ignacio Tirado, to give us his greeting speech. Ladies and gentlemen, please welcome him with a big hand of applause.
Hello, everyone. Good afternoon in Seoul. Good morning from a very sunny, bright autumn day here in Rome. Thank you very, very much. I'm very honored to be invited and to speak in this very important event organized so well by the Judicial Policy Research Institute. I'd like to, first of all, express reference to the honor of sharing the panel with the President of the Judicial Policy Research Institute and the Chief Justice of the Supreme Court, who have delivered the greeting speeches this morning, as well as with Judge Yoon, who is going to be chairing this long discussion session, and to all the experts and good friends that have been speaking throughout the morning in Korea. This is an extremely timely and important event, which can be seen not only by the extraordinary level of the participants from Korea and from the region, but also because of the times that we are living. Let me, before I go into the substantive matter of the speech, a brief one, no worries. Allow me to say that while I am thrilled to be here, I very much regret not being able to be in Seoul in person, because there is nothing I would have liked more than to visit Korea. Korea has been very much up in my list, both professionally as Secretary General and personally as a world traveler for many, many years. And I hope that I will have the chance to visit in person soon enough. Why is this an important event? And it's an important event because of the content, and it's an important event because of the time. It is an important event because of the content, because what it does is it brings together the legal community of Korea and with experts from the region, together with the three sisters, with the representatives of the three intergovernmental organizations that conform the, say, elite of the transnational law organizations. Of course, it is always a pleasure to share an event with our colleagues and friends from the Hague Conference on Private International Law and UNCITRAL, with whom we share so much and with whom we coordinate so often and share instruments and activities. But it is this activity of transnational organizations in these times of crisis that becomes especially relevant in our opinion. We are in the middle of one of the most terrible pandemics that we have a memory of, and we are definitely no experts in medicine, so that is not the health part that we're concerned with. It is the economic crisis and the way that this pandemic is, and the measures adopted as a consequence of the pandemic by the governments that affects private law and contracts between the parties, and the situation of businesses, that is absolutely key. We are in the middle, and I'm afraid to say only at the beginning, actually, of a global economic downturn. And this is a time when the work of transnational organizations becomes especially relevant. It is a time when a good, solid, best practice-based world order can contribute greatly to help stabilize the situation, to help countries grow, to help go back to the international exchanges that were taking place before the pandemic and which got interrupted, at least partially, as a consequence of the measures adopted to avoid the damage of the health crisis. So it is international, transnational organizations such as UNIDROIT and The Hague and UNCITRAL which provide a framework which being considered best practice and best standards. Therefore, it is far from domestic local approach, which in these times of uncertainty tends to be too focused on the specific needs of a very moment in time, and therefore any legislation which is passed domestically tends not to be long enduring in time and tends to be biased time-wise. Our norms, however, are the result of a consensus by worldwide experts and are designed in a way to last in time, not just to be applied locally and to try to confront a situation which happens right now. It is this type of enduring norms that provide, if adopted, a stability and a relief, a certainty, which is most needed in international commerce and international transactions, because what investors are always trying to avoid is legal uncertainty. A sound transnational regime allows them to trust the legal framework, and by trusting the legal framework, they will be happy to go back to the old trading and to the old system of exchanges. This legal certainty lowers transaction costs and is very favorable globally to everyone. This crisis has been especially hard and will be especially hard because confidence is undermined in the subject of access to finance. And such a subject of access to finance, and this is the province of what the previous sessions were talking about, secure transactions, for example, are a very important part. Secure transactions and contracts, which were part of today's discussion, are two areas where our organizations, and especially UNIDROIT, for whom I'm speaking only, obviously, have concentrated for a very long time and have produced very important instruments. So let me give you just a few examples. An instrument which is absolutely key and which you will have heard me talk about earlier in the area of secure transactions is our Cape Town Convention on International Interest on mobile equipment, high-value, uniquely identifiable equipment with its 4 protocols. The protocol for aircraft, airframes, engines and helicopters, the rail protocol, protocol on rolling stock, the space protocol, and most recently our creature, which is hardly 1 year old, which is the MAC protocol, which concerns mining, agricultural and construction equipment. This constellation of protocols and the convention, this convention system constitutes one of the most successful commercial treaties in history. And this is not just my opinion, it is the numbers that speak for it. We have now 82 members, with the vast majority of the world being part of Cape Town, both in terms of population and in terms of GDP. To give you just an example, which was mentioned before in my presentation, I think it is very important to highlight again the economic efficiency of Cape Town Cape Town provides so much legal certainty and is capable of lowering the risk of credit so much that an international objective organization completely detached from our organization, of course, as is the OECD, includes the Cape Town discount, which allows export agencies to charge 10% less to finance the transactions of a borrower, simply because the country where the borrower is placed is a Cape Town country. So simply because Cape Town applies, it is immediately understood that the risk of credit is the risk of default for creditor is much lower, and therefore it is possible to charge a lower interest rate. This is the most clear example that can be seen of how an international convention of transnational law, of a transnational law organization, is able to produce extraordinary results for the market and for the different countries throughout the world. As we move forward, it will be precisely this type of instrument which provide legal certainty, which gives certainty to the rights of the parties to a transaction, which will be key to the recovery of countries and to allow countries to thrive and to grow again. If we look at Korea, for example, although unfortunately, and hopefully this might change in the future, Korea is not a Cape Town country, is one of the few in the region of important countries that is not. The Korean legal system is, of course, excellent and sophisticated, but it is not enough to have a very good legal system to ignore Cape Town. And let me explain to you why. It is in the interest, it would be, I reckon, with humility and respect, important for Korea to join Cape Town, not because it would apply to transactions where the borrowers, the debtors are Korean, but because it would apply to those transactions where the borrowers or the debtors, those who import from Korea, are Cape Town countries. So if Korea joins Cape Town, the fact it will be sending out a message to other countries that if they are Cape Town, Korean industries and Korean companies may export the equipment to those countries at a lower risk, and therefore they may export more and they may export a lower rate. So Cape Town is not only important for importing countries, it is absolutely key for importing countries, of course. It is also very important for exporting countries because it facilitates the business with countries which have legal systems which are less reliable. And it is this part of Cape Town which is sometimes overlooked by governments. I would encourage you to think about this as a new approach. Another instrument of our organization, which soon will be 100 years old, by the way, not the instrument, the organization. Another instrument which you have already been speaking about is the UNIDROIT principles on international commercial contracts. As you have heard, we are here talking about a best practice instrument on international commercial contracts, not just sales, but any type of commercial contract. And here is the difference and the reason why it coexists very peacefully and very nicely with the CISG, which has been widely discussed. The UNIDROIT principles are a prodigy of balance because they were drafted by some of the most important experts in commercial law and in contract law from the world, from the different legal families, from the different geographical regions. So it is a prodigy of balance between all the global approaches to commercial law. And this makes them particularly flexible, and that makes them particularly apt to solve problems in a time of uncertainty such as the one we are going through now. So as we all know, the pandemic and the measures implemented by governments to stave off the risk caused by the pandemic has interfered substantially with a vast number of contracts, millions of contracts around the world. Many of those contracts are very valid, good commercial exchanges, and we don't want to destroy the value of those contracts. Those contracts ought to be preserved to the extent possible, because many of them actually represent just a moment in time of a long-standing commercial relationship. And we don't want that to break just because of a temporary situation. That is why a flexible set of principles, which has very innovative, state-of-the-art solution for hardship and for force majeure, which can be extremely important when it comes to solving problems. It offers a framework for an adequate renegotiation, which allows the parties to go back to the equilibrium, to the balance which was set initially in the contract. These commercial contracts, these principles of UNIDROIT, have been used consistently to influence legal frameworks, the legislature. Our instrument on hardship and force majeure has influenced the recent reforms in countries such as China, Russia, or France, only to mention some of them. And this is so because they are regarded as best practice. So apart from influencing legislature, they are important because they can help the parties draft clauses to tackle the situation of the pandemic going forward. And they, of course, are and can be used by the parties in arbitration, and sometimes, depending on the framework, even in court cases. I'd like to finalize my initial remarks by highlighting, though, always in the area of access to credit and private law, a couple of projects that we are now undergoing. We are now starting strong, but we are in the initial stages, which we share with directly or indirectly with our friends and colleagues from UNCITRAL. I'd like to make a special reference to our current work in the drafting of a model law on factoring, reverse factoring and supply chain financing, which promises to be absolutely key in access to finance, especially in developing countries. The factoring model law, of course, adopts a functional approach, which is absolutely consistent and complementary to the model law on secure transactions, which has been approved by UNCITRAL and which is and embodies best practice internationally. Together with UNCITRAL, and very much linked with our work on factoring, is the current drafting of a model law on warehouse receipts financing. This is an area which promises to be key, especially in developing countries and in countries where agriculture is very important. Finally, I'd like to also make a reference to our work, also closely related with UNCITRAL and The Hague, on digital assets, where we are undertaking work on the private law side of digital assets, and how we are, together with UNCITRAL, creating a taxonomy. And more generally, in our working group, we are working towards the definition of private law issues such as secure transactions over digital assets, insolvency matters, private international law matters, and anything which can be applicable to property rights and digital assets. So just to keep you up to date to where we stand and what we're doing now, thank you for listening to these general remarks, and I hope to have convinced you to some extent that transnational law institutions have a very important role to play going forward. And now I will hand over the floor to the panel, thanking you all very much for your attention and looking forward to the discussion. Thank you.
Thank you, Professor Terodo. Please give him a big round of applause once again. Now, I have the pleasure of introducing our moderator of the final session. The moderator of this session is Judge Sung-Gun Yoon, the presiding judge of Seoul High Court. Mr. Sung-Gun Yoon was appointed as judge of the Incheon District Court in 1998 and later as presiding judge of Seoul High Court in 2010. Prior to serving as a judge, he worked as an attorney at law at Kim Yen-jang, handling corporate international transaction and transnational investment-related matters. He received LLB and LLM from Seoul National University and LLM from University of Michigan, respectively. He formerly served as a Korea delegate to the UNCITRAL working group. He is an eminent practitioner in the area of international commercial law. Without further delay, I would like to turn the floor over to Judge Yoon.
Okay, thank you very much. First, I feel obliged to express gratitude to the three organizations that have been working on the unification and harmonization of international private law and commercial law. I deeply appreciate the efforts and progress made so far and the benefits that we all enjoy from the results. The presentation we all witnessed today may seem a little bit general, so it may look like some kind of lecture to somebody, but still, it was very informative, enlightening, and even intriguing, well prepared by outstanding experts and professionals. So I feel very satisfied and pleased to be here to enjoy the feast of intellectual joy. As you know, we have many speakers and panelists in this session, 15. And only after the session we can have dinner. So your dinner will be at our mercy. So I'll try my best to save you from the hunger, even though I do not feel really hungry because of the feast, as I mentioned. Speakers and panelists, please keep the time schedule. You each have 5 to 7 minutes. For the first session, we have first panelist, Professor Jung Hong-sik from Jungwon University School of Law. Professor Jung, you have the floor. Please go ahead.
Thank you for the introduction, Judge Yoon. Well, it is my honor and privilege to be part of this conference. For the discussion of session 1, I will present 3 points. First is about the results of an arbitration survey that was conducted in 2017, and will show what type of dispute resolution method that Korean parties must prefer. The second is about the brief explanation of a choice of law provisions under Korean Act on Private International Law. The third is about my own suggestion to proactive use of unilateral principles for economic benefits of Korean companies and Korean legal practitioners. In 2017, I and other 2 colleagues conducted arbitration survey toward Korean legal practitioners. We collected 148 responses in total, almost one half from in-house counsel and the other half from law firm lawyers. The industries where the responded in-house counsel were belonging to were very diverse. It is including construction, energy, manufacturing, finance and insurance, technology, transportation, etc. With respect to the survey question as to what kind of dispute resolution method you must prefer in drafting international contract, we have got the result that the preference for international arbitration is way above international litigation. As you see the diagram, a preference for international arbitration is about 70%, while the preference for international litigation is only 11%. The survey result is not surprising. It is consistent, almost consistent with the result of arbitration survey annually conducted by Queen Mary University toward the worldwide legal practitioners. I can tell you that most of the responders favoring international litigation are from finance industry. It is well known that the finance sectors favor litigation over arbitration because a loan agreement is quite simple, so that the lenders want to enforce the contract itself through the court litigation. Lenders are reluctant to agree to a way of dispute resolution by arbitration because they have a perception on the arbitration that the arbitrator just renders an arbitral award deciding somewhere between the parties' respective positions. That is why the lenders must prefer the litigation as a dispute resolution method over arbitration. Of course, there are many court cases involving international contracts because there was no prior agreement by the parties as to dispute resolution method. If then, the court litigation is a default procedure to resolve the contractual dispute. For example, Korean courts are exercising jurisdiction over many contractual disputes involving a sale of goods and have been applying CISG to that dispute if it is applicable. Korean Act on Private International Law has relevant provisions as to choice of law governing contractual dispute. Pursuant to Article 25 of the Korean Act, a party autonomy for the choice of law is completely respected. The Korean court should recognize rules of law, such as unidroit principles, if parties expressly or impliedly agree to apply. However, I have no information as to whether Korean courts have actually applied the unidroit principles when the parties expressly or impliedly agree to apply. I believe other distinguished discussants may discuss this matter in a few moments. In case of a dispute arising from a sale of goods, in the meantime, the Korean courts have consistently applied the CISG. If the governing law chosen is one of signatory countries of the CISG, including Korea. In the absence of parties' agreement as to governing law, pursuant to Article 26 of the Korean Act, the court should determine a specific national law of the country, which is most closely connected with the contract. In this case, we interpret that Article 26 of the Korean Act does not allow Korean courts to apply a soft law like a unidroit principles to the contractual dispute. Only a national law should be determined and applied. In case of sales dispute having no prior agreement as to a governing law, Korean courts have applied the CISG if the country most closely connected with the contract is determined one of the signatory countries of CISG. If CISG is not sufficient enough to cover a subject matter of the dispute between the parties, then the Korean court must apply civil or commercial law of that country determined to be applicable. As a third point, I'd like to suggest the Korean companies and legal practitioners to actively use UNIDROIT principles in non-sales transactions for their economic benefits. Korean companies are doing tremendous amount of businesses overseas, particularly in developing and less developed countries. Types of businesses are mostly construction and infrastructure development. Governing law chosen in such non-sales transactions may differ, but the Korean parties heavily rely on English law in most part. Otherwise, a local law of the country where such a business is conducted will be selected. What happens if English law is chosen as a governing law in a big construction arbitration case? Well, most Korean companies hire international law firms to prosecute or defend their arbitration cases and spend a lot of legal expenses, not only because the international firms are quite expensive, but also because the parties mostly appoint English qualified arbitrators, like English Queen's Counsel. The appointed arbitrators will administer the case under English style of litigation or English style of arbitral procedure. Where sometimes both parties are all Korean parties, but fight against each other in front of the three English Queen's Counsel with translation into English. And the representing legal counsel also are English qualified professionals. Well, this is quite sad moment from my standpoint. As the Korean parties are going through the arbitration process, they are shocked and screaming when they receive a billing statement that charges surprisingly high amount of legal fees and arbitration expenses incurred. Sometimes more than $10 million are likely to be incurred by each party in a big arbitration case. In the event they completely lose the case, then the fees and expenses will be double to the most. It is quite burdensome on Korean parties, Korean companies, which are not only cost sensitive, but also just enjoying less than 10% profit margin in the specific project. On the other hand, what happens if a local law is chosen? In many cases, such a local law in developing or less developed countries is a kind of unknown world to the Korean parties. What if the local language is chosen as an arbitration language, along with the local law as a governing law? Well, it will be a disaster or nightmare to the Korean parties. For instance, one of the Korean representing construction companies has conducted an arbitration case under that such combined setting of local language and local law for more than 10 years before they finally settled. If a dispute arises out of such a non-sales transaction, it is well known that the factual issues are way more than legal issues. Well, that means application of a specific governing law is very rare because factual determination by the arbitral tribunal or the court is most critical in resolving the dispute. Nonetheless, Korean companies are most likely to engage legal counsel who are qualified in the jurisdiction of the governing law chosen. What will happen if UNIDROIT principle is chosen as a governing rules of law? What are the possible effects of using UNIDROIT principles as governing rules of law? First, it may bring more opportunities to Korean law firms for a sole representation of Korean companies in a big arbitration case, because it is not definitely necessary for Korean parties to hire expensive international firms. I believe that the Korean arbitration experts are quite competitive in a worldwide basis to solely represent Korean parties in a big arbitration case. Korean lawyers have no barrier in dealing with UNIDROIT principles as a governing rules of law to the case, even if UNIDROIT principles have no provision to deal with a specific issue in the case, so that the specific national law shall be determined and applied, which is quite rare situation. I believe that the Korean firms will be able to handle that situation by using legal experts in the arbitration process. Second, because Korean law firms is relatively cheaper than international firms, Korean companies at the same time will be able to reduce a substantial amount of legal expenses if they hire Korean law firm only. It can boost up Korean legal industry and at the same time bring more benefits to the Korean companies. Third, uncertainty and anxiety arising from the application of unknown local governing law will be dramatically reduced if the UNIDROIT principles is applied. Having said that, we can enhance predictability as to a possible result of that dispute. In conclusion, for the economic benefits of Korean companies and legal practitioners, I suggest active use of UNIDROIT principles as a governing rules of law to be taken into account. Well, I believe this logic and my suggestion will also be applicable to other countries' situation as well. Why not? Thank you very much for your attention.
Good. Thank you, Professor Chung, for your valuable observations and suggestions. And now the next panelist, Judge In-jun Hwang from Uijeongbu District Court. Judge Hwang, are you ready? Please go ahead.
Thank you, Chair. Good afternoon and good morning to our distinguished European colleagues, and good evening to Justice Goddard in Wellington. First of all, I would also like to extend my sincere gratitude to presenters for a wonderful presentation in session 1. It might be a long journey to dinner if I read whole text here. I will just skip over the first 2 paragraphs. In first 2 paragraphs, I would like to point out that there is no transnational court of last resort with the authority to decide on legal issues arising out of international instruments. And such a lack of final authority may lead to courts and tribunals reaching different decisions on the same legal issues. Databases such as Cloud by UNCITRAL and Unilex by UNIDROIT play an important role in assisting the courts and tribunals to interpret the instruments in a uniform manner. And tripartite guide will be an important step forward to achieve autonomous and uniform interpretation of the instruments. And also I think that this conference will be meaningful chance for members of Korean judiciary in this regard. So now turn to 3 instruments in South Korea. Since South Korea ratified the CISG in 2005, CISG became the most successful international instrument governing legal issues arising out of cross-border transactions. As noted in session 1, 27 Korean judgments rendered up to 2015 were reported on Cloud by distinguished colleague just sitting beside me. And from 2016 to present, Korean courts apply a CISG as the governing law in 29 cases, as you see the chart on page 121. I've missed my citation here. This is based on my personal research, and it might be different from the official statistics. And it's different from the number of my colleagues' presentation because I counted just 1 case if a court of first instance rendered a judgment on CISG, and the appeal of that was dismissed. And in 1 decision from Seoul High Court, the court made reference to and cited CISG as the general principle of international commercial contract in its reasoning, even though it was not a governing law. And the majority of the cases from 2016 were related to a dispute between Korean party and Chinese party. As you see on the chart, cases where the courts need to apply CISG as the governing law have been increasing, and it's likely this trend will continue. Academics argue that judgments based on CISG could be more persuasive and convincing if the court clearly provides citation of foreign judgments or any other resources referred to by the court. As Article 7.1 of CISG provides, uniformity in application is one of the main philosophy of CISG. So Korean judges dealing with international commercial cases may take this view into consideration positively. With regard to UNISRAW principles, there is no judgments found where a court applied it as an applicable law. But in one case, a party claimed there is a discrepancy between contracts drafted in two languages and argued for the application of UNISRAW principles, Article 4.7. However, the court denied application of UNISRAW principles on the ground that a Korean law should be applied as the governing law in the case. In arbitration, UNISRAW principles has been known to be used as an applicable law, and there may have been a case involving Korean party or at a tribunal seated in Korea. However, due to main feature of arbitration, namely confidentiality, it's difficult to find a reported arbitration case where the UNISRAW principle has been applied as a governing law. This is except which is already reported in UNILEX database. And Hague principles on choice of law in international commercial contracts is relatively a new instrument, and so no court cases has been found where a Korean court referred to the principles in its reasoning. But Judicial Research and Training Institute published a translated version of the instruments and commentary in 2017, which was done by Judge Hye-rang Lee. And that documentation is accessible at the homepage of Hague Conference. Now, I would like to wrap up my discussion with questioning to each presenter. The first question is for Mr. Professor Sono, who just gave us a presentation in session 1. In relation to a tripartite guide, I would like to ask whether there have been any issues identified thus far which seem to be incompatible among the instruments. If the future guide will suggest a best way of application of each instrument to ensure uniform interpretation, I would like to know if there has been any instance where several courts have made decisions that contradict each other, and if so, whether such wish will be touched upon in the future guide. And I think a uniform application of each instrument is essential for the parties' predictability and certainty. But this seems to be a little bit difficult to achieve from the point of view of as an adjudicator. In Professor Sono's presentation, the issue of interest rates in CISG was mentioned and how it could be supplemented by UNISRAW principles. However, in a case involving CISG, a Korean court decided the interest rate should be settled based on the governing law chosen by virtue of Korean private international law rules. It seems to be clear that adjudicator should not simply apply private international law rules without exploring whether there is general principles exist in CISG case. Having said that, adjudicator would be reluctant to apply principles such as UNISRAW principles in a case where neither party has claimed its application during the proceedings, nor is even aware of its existence. In this regard, I wonder to what extent a uniform interpretation of international instruments should be or could be achieved. The second question is for the Deputy Secretary General of UNISRAW. UNISRAW principles works as an applicable law or principles for reference in arbitration cases rather than court proceedings. As mentioned above, arbitral awards tend to remain confidential, so it's difficult to learn about the existence of a case governed by UNISRAW principles and the contents of such an award. in my opinion, if more cases and precedents were open to the public, the use of UNIDROIT principles could be facilitated and its acceptance as concrete general principles regarding international commercial contract may be increased. In this regard, I would like to know if there has been any effort by UNIDROIT to tackle these kinds of issues or to facilitate the use of UNIDROIT principles. Lastly, I would like to ask to the first Secretary of Hague Conference. In the presentation regarding Hague principles, it was introduced that Paraguay's new legal regimes on the choice of law rules was inspired by Hague principles. I would like to ask if which changes were inspired by Hague principles, and if any, what provisions or features of Hague principles was excluded from being adopted. Thank you very much.
Thank you. Thank you, Judge Huang, for your meaningful research and comments and questions raised. Now, Judge Haemin Lee from Suwon District Court, Anyang Branch. Are you ready? Please go ahead.
Good afternoon, everyone, and good morning to the colleagues overseas. My name is Haemin Lee, and I am a district court judge here in Korea. It is my great honor to be invited here to speak at this conference with such distinguished speakers, panelists, and moderators. So I would like to take this rare opportunity to briefly introduce how the international instruments introduced by the speakers are being applied in Korean courts and Korean judiciary's efforts behind it. But only within the range that it is not overlapping with the prior presentations. And then I will be asking a few follow-up questions to the speakers. I have a short presentation to give, so please refer to the slides on the screen, and thank you very much for your time in advance. As cross-border contracts and disputes increase, the Korean judiciary has put in a lot of efforts to enhance the court's understanding of relevant norms and to keep up with current trends. These efforts include publishing a manual for judges on international transaction trials and running specialized benches for such cases, or even dispatching judges to international organizations as a member of working groups or as a judge on secondment. In addition, the Korean judiciary has built close relationship with UNCITRAL as well. As honorably elaborated by my colleague, I myself have been a national correspondent for UNCITRAL Cloud System since 2009, and I was appointed by Supreme Court of Korea. And so far, 45 judgments have been reported and included in the UNCITRAL's database. I have more cases to report, but the UNCITRAL is asking me to cut down the numbers due to the sake of expense, so we are actually dealing with the issue now, but I think we can make proper progress with it. And in particular, among the instruments introduced, the CISG is playing a significant role in Korean courts as it functions as a special law to Korean civil and commercial law. And I will not go into detail as it was very well elaborated by the colleagues as well. In 2015, I had an opportunity to speak at a conference held by UNCITRAL to celebrate the 10-year anniversary of the CISG in Korea. And at this time, the number of CISG applied decisions was 35. Now in 2020, 5 years from then, the number of cases has already doubled and is increasing. I also found that a large number of issues and articles are being mentioned and covered in court cases. On the other hand, the Korean courts or parties do not appear to be actively using the principles of UNIDROIT or HECCH yet. There was one case which Judge Hwang just introduced, and in the case, the UNIDROIT was argued by a party to be applicable, but however, the argument was rejected by the court. I do expect that we might be able to find more active use of the principles in the area of arbitration, and the Korean courts are trying hard to promote arbitration as well. So this has been a very brief overview of current trends and efforts of Korean courts in the application of international instruments in cross-border contracts. Internally, I believe that more comparative research by Korean judiciary and academia would be necessary in order to achieve harmonious application of laws and norms. Now, turning to the international side, I would like to ask honorable speakers, Dr. Ana Veneziano and Dr. Joao Ribeiro Bidawi, concerning that if you have specific plans to further promote the instruments among parties and states. It is my observation that one major obstacle when applying such rules in cases has been that often the parties and practitioners are not aware of such rules. In addition to that, recently I've noticed that some parties are explicitly opting out from applying the said principles in court cases and rather relying on traditional laws of states. So I was wondering if you have any plans to deal with such situations. And my second question goes to all the three speakers. What your opinion is on the whether the perspective of the civil law states is being equally reflected in the formation of international norms. And if you could introduce how gaps between the civil law and common law traditions can be fairly resolved when such principles are being formed at the international level. I understand that Professor Sono is playing an important role as an expert, especially when the tripartite guide was formed. So I think we would be able to hear valuable opinions from the three speakers. And I was planning to give these only two questions, but just one other question came to my mind when Judge Hwang was speaking. I would like to add a slightly different perspective and question to the question that was asked by Judge Hwang, which is Professor Sono mentioned that the CISG Advisory Council opinion is giving another interpretation to fill the gaps of the CISG. And also Professor Sono mentioned that the UPICC is supplementing the CISG. And I think this is a very valuable approach to fill the gaps and to make harmonious interpretations. However, I am a little worried that this might be a little challenge to domestic courts when they apply the conventions, especially in terms of judicial sovereignty. So I was wondering if the organizations has any idea in making balance between harmonious and uniform interpretation and also the judicial sovereignty of each domestic court. And also it might affect a little bit on the state parties' right to make reservation when they are making, when they are entering certain contracts, certain conventions. So I was wondering if you have any views on that point as well. So this concludes my brief discussion on this issue. And again, I appreciate the speakers for sharing your experiences and insights with us. And thank you all for your time and attention. Thank you.
Thank you. Thank you very much, Judge Lee, for your in-depth discussion focusing on CISG, and also thank you for your efforts so far to let the Korean cases known to the world. Thank you. And now we are going back to our speakers to listen their observations and answers on the issues raised by our panelists. Professor Hiro Sono, are you there?
Yes, I am. Can you hear me?
Yes, thank you. You have the floor. Go ahead.
Thank you. Thank you, Judge Yoon, for giving me the floor. Well, I have to say that I was very impressed by listening to the three panelists about the role that the Korean judiciary and the legal community is playing in developing international commercial contract law. And you have posed very interesting and difficult questions for me to answer. I will try to answer them to the best of my ability. The first question that came from Judge Hwang was whether there is incompatibility between between the CISG and other uniform law instruments. And yes, there are there are matters where each instruments provide different rules. One example would be, I briefly touched upon the limitation convention in my presentation this morning. The limitation convention provides for a 4 years limitation period for international sale of goods, whereas the UNIDROIT principles, they also have rules or principles on the limitation period. There they have the rule that the limitation period is 3 years. And this is a different rule adopted by these two instruments, and there clearly is clearly are incompatibility here. How do we solve this incompatibility? If the limitation convention applies as applicable law, then that will have priority over the UNIDROIT principles. But if the limitation convention does not apply, then it will be the UNIDROIT principles. If at all it applies, it will be the UNIDROIT principles that will apply. So well, that's one example of incompatibility. Another incompatibility is the question, or another potential incompatibility is the question of interest rate that, as we have been discussing a couple of times. The UNIDROIT principles provides that it is the rate at the place of the payment, and the possible interpretation of the CISG would point to the interest rate at the creditor's place of business. This can be an incompatible rule. And as Judge Hwan has rightly pointed out, there can be a confusion about which law or which interpretation to apply. However, I would first like to point you to Article 7, Paragraph 2 of the CISG, which clearly states the hierarchy of norms. If the CISG is applicable, it is the CISG that has priority. If the CISG does not provide for a rule, then it is the otherwise applicable law that will be applied through the international private law. However, in between that, before jumping right into the application of international private law and national laws, Article 7, Paragraph 2 requires that the interpreter to consider what the general principle underlying the CISG are. And if there is a general principle that can be identified, it is that that principle applies prior to national laws. So especially as for the question of interest rate, Judge Hwan has mentioned that the Korean courts have been applying the statutory rate of the governing law, of the applicable law. That, in my view, is possible only if the interest rate is not a matter that is governed by the CISG, or if general principle of the CISG that relates to interest rate cannot be identified. However, the CISG Advisory Council's position is that it can be identified. And it is that since interest for late payment are one form of damages, the rate at the creditor's place of business should be used, because that will be the rate at which the creditor will be borrowing the money that he did not receive from the debtor. So that's the rationale behind the CISG Advisory Council's opinion, and since it is a general principle under the CISG, underlying the CISG, that one takes priority. there are three layers of norms. One is the explicit provisions of the CISG, and if there are no explicit provisions, you have to look into the general principles underlying the CISG by interpretation of the CISG. And then after that, if there are no general principles, you go to national laws. So that is the idea under Article 7, paragraph 2. I think I need to speed up a little bit in answering my questions. Judge on Hyemin Lee has asked, I think we've met at the 10-year anniversary of the CISG conference. She has been saying that there are many Korean court cases, and that's wonderful. From Japan, we only have 3 for the moment. And her question was about civil law versus common law. When we are applying the CISG, we are not applying civil law rule or common law rule. We are applying the CISG as an independent rule. And of course, each interpreter will have their background of national law, and that might affect their interpretation. But in the end of the day, you have to interpret the CISG itself. And Article 7, paragraph 1 would require that requires an international interpretation or a uniform interpretation of the CISG, and the difference between civil law and common law should not affect the outcome of the interpretation. And as for the question of judicial sovereignty, yes, judicial sovereignty, of course, is recognized. Each state can make reservations that are made available under the CISG. And each court has the power to interpret the CISG as they wish. However, Article 7.1, again, of the CISG requires that regard is to be had to the international character and to the significance of uniformity in the interpretation, and therefore that's why we have to look into what other courts are doing in other jurisdictions, and the cloud system to which Korea is contributing a lot. That is one system that allows that, that makes it possible. Foreign court decisions are not binding. They only have persuasive authority, and I think judicial sovereignty, we're not trying to take away judicial sovereignty. It's up to each courts to, in the end of the day, it's up to each courts to decide whether they think is the right interpretation. I am afraid I did not answer all of the questions, but allow me to stop here. Thank you.
Thank you. Thank you, Professor Sono, for your thoughtful answers and excellent observations. Now we have Professor Anna Veneziano for our second speaker. Professor Veneziano, are you there?
Yes, I'm here. Thank you very much, Chair, for introducing me, and I am really honored to be here. Very grateful for the organization of the conference, and extremely grateful for all the comments and inputs that we received. I must say I learned about important initiatives and also features of Korean law I was not aware of, so thank you very much. Allow me to start with a general observation that I think touches upon many of the things that were discussed by our eminent panelists in relation to the UNIDROIT principles. I think it is clear from what they said, and I really support this view, that the UNIDROIT principles as a soft law instrument are actually to be seen as a tool for parties and also for adjudicators, certainly arbitrators, that was underlined, but also, as I will say, judges in different possible ways. And so, of course, they are not a panacea. They do not have to be applied in every situation, but the idea is that they can be considered useful in many situations where you have an international contract. And arbitration is the most natural environment, certainly, for the principles. And I think Professor Chung referred in a commendably practical manner to the downsides, which are both legal and economic, of choosing in many situations a law which is foreign to one or both parties even, or a specific domestic law in an international situation where the UNIDROIT principles could enable arbitrators and parties to find a balanced solutions. We have, for example, cases where the UPIC were introduced after the dispute had already been opened, and they really helped finding a settlement or a good solution during the dispute. And the second important point that was made by the commentators regarded the courts and the role of soft law, including the UNIDROIT principles, in court decisions. And I was happy to hear that the Korean courts are actually allowed to apply soft law to the contract if parties expressly or impliedly choose it, which is an open attitude towards soft law, which is not shared in all legal systems, but looks at the future. At the same time, the important point that was made by many commentators is that I understand it is necessary for parties to impliedly or expressly choose this soft law. And this brings me to one of the questions that was put by more than one commentator, the question of knowledge of the existence and of the benefits of the soft law and of the UNIDROIT principles. This is an extremely good point. We saw that when the UNIDROIT principles are actually read, are known, they are actually appreciated. And so the good question is how to increase this knowledge. Now, we have undertaken a number of initiatives. They are never sufficient. We are small organizations, so I will come back to this point. One of the important initiatives was to work together with the organizations of practicing lawyers and arbitrators. We had an endorsement recently by the Union Internationale des Avocats. We are working closely with the international bar associations. We are liaising with in-house counsels, but actually we have to rely on the work of those who know the principles, both in academia and in practice. And something like the present conference is really one of the most powerful instruments to spread the knowledge of the existence of the UNIDROIT principles. So in a way, it also judges and academics like the ones in this audience are the ones who can help us spreading the knowledge on the UNIDROIT principles. We have initiatives, but we are also very happy to support or to receive indication of the possibility to have other initiatives. The second answer I would like to give is on the questions that were raised and comments that were made on the relationship between the UNIDROIT principles and international hard law instruments such as the CSG on the one hand, and also domestic law on the other hand. And I would like to underline the point that the UNIDROIT principles do not mean to substitute the interpretation parameters of an instrument such as CSG. They can, however, and here I'm really convinced of this, they can, however, support the identification of general principles in CSG because those principles are not actually expressly stated and that are the result of an interpretation. Of course, if the interpretation, the prevailing interpretations goes in another way, that interpretation will be followed by the majority of courts. But there are many situations where the UNIDROIT principles can really underpin general principles existing in CSG, for example, for liquidated damages, for giving more importance to good faith. This support role has been used in practice and can be used by the UNIDROIT principles also with reference to domestic law. So this is another way that the UNIDROIT principles can be useful in court proceedings, even if they have not been chosen directly by the parties. They would not be considered the law applicable to this dispute, but they can be referred to, they have been referred to as a support for the interpretation of domestic law, especially when domestic law is in flux, is developing, and some new principles are emerging, and the UNIDROIT principles can help underpin those new principles, going more in favor of party autonomy, going more in favor of favor contractors, of keeping the value of the contract, as the Secretary General said at the beginning, and more in favor of certainty in international commercial relations. So we have examples of this. We would like to see more examples, but particularly in applying, referring to the rules of the interpretation of the contract in many jurisdictions, or to the rules on the limits to termination of the contract and the meaning of fundamental non-performance as a limit to the remedy of termination of the contract, and many others. So in this case, the judges would not be applying the UNIDROIT principles as the law applicable to the contract, but they would be referring to them as a support argument for the interpretation of domestic law. I think this is what I would like to say in respect to the very valuable comments that were made by our commentators, and I cannot but commend the initiatives to try to spread the knowledge of this a soft law instrument such as the UNIDROIT principle, especially in Korea. I understand that we don't have knowledge of the fact that they have been actually applied in practice. It might be the case. We understand the difficulties in gathering this knowledge, but we think that the mere fact that Korean law would allow for the choice of the soft law instrument, if parties did so expressly or impliedly, is a very good starting point. We think that here we have to add the knowledge, and we have to underline this role of bridge between different legal systems and different approaches to the law that is achieved in the UNIDROIT principles, especially because they help the development of international contracts. So they are particularly useful in that context. Of course, it's their scope of application and main ambit of application. So the last point I would like to make is really in respect to one of the issues that were touched upon by the Secretary General at the beginning. One example of how the UNIDROIT principles can bridge this gap that was referred to in the comments, the idea of favoring the value of an existing contract, especially if it's a long-term contract. If you look at the UNIDROIT principles, you can see many provisions and many tools that judges, arbitrators, and also parties can choose, and parties can also adapt because the party autonomy is paramount in this respect in order for their contract to be still valuable even if adverse events, like for example hardships events, apply or occur. So we think that the UNIDROIT principles represent this flexible tool that can be applied in, particularly, though not only, but particularly in those situations. Thank you very much for your attention, and of course I'm open to any other comments or inputs that you would like to make. And thank you again, Chair, for giving me the floor.
Thank you. Thank you, Professor Veneziano, for your in-depth answer and observations on these very difficult issues. Now we are completing the discussion for the first session by the last speaker, Dr. Ribeiro Vidaui. Are you there? Oh, okay. You have the floor. Go ahead.
Thank you very much, Chair, for giving me the screen rather than the floor. And I very much appreciate your flexibility and the flexibility of the organizers in allowing us to send a pre-recording video and to participate remotely in this very important conference that we supported from the outset. And of course, a special word and greetings to some friends in the room after 5 years in Korea, also working with JPRI when I was at the Ancitral Regional Center for Asia and the Pacific. Going directly into the questions, Judge Lee asked about the promotion and what we are doing or can do to promote these instruments, and in particular the Hague Principles or the HECH Principles as we now prefer to call them. Well, first of all, this conference is a remarkable example of what can be done to promote the principles, directly speaking to the judiciary and highlighting their relevance. And indeed, we are trying to replicate this example, and this will be an inspiration for sure in other jurisdictions. I want to also share with you that a publication will come out early next year, coordinated by Professor Ginsberger. He was the chair of the special commission that approved the Hague Principles. And this publication will gather reports from around the world on how the principles are being used, and we expect, and also includes a contribution by the Permanent Bureau of the Hague Conference on how to promote the principles, and that publication is expected early next year. In particular, also, as I briefly mentioned in my intervention in the morning, we started this year annual survey that is addressed to arbitration institutions from around the world. And as a result of that survey, we publish a status table that reflects how arbitration institutions have somehow incorporated or accommodated the tenets of the principles in their arbitration rules, or even if they have reported cases or awards that have referred to the principles. And we just published that status table for the first time, and our proposition is to do this every year. So it has a two-way function, in the sense that by reaching out to the arbitration centers, we are promoting the principles, and also it will allow them to report to us to what extent the principles are being used. Another way in which we promote the principles is working with the World Bank, and we do that when the World Bank is engaged in legal reforms, especially in transitioning economies, and when they support the review or reform of contractual law. We usually work with them so that we assist that state to draft such laws and take the opportunity to suggest the incorporation of the principles. And I will come back with a specific example when answering to Justice Huang. Also, another very important way of promoting the principles is by incentivizing judicial training institutions to incorporate the principles in their training, even if I very much know that we do not train judges. We just share knowledge with judges. But in those opportunities, of course, judicial training institutions are very important in the promotion of the principles. But also, and I know that GPRI has very extensive and relevant programs in assisting training and capacity building of judges from developing countries, also in that mission, having these judicial training institutions to incorporate in their curricula the principles. So regarding Justice Lee, a question about promotion, that's what I would like to share. Before addressing the question of Justice Wang, and please indulge me with a very side comment on the issue of judicial sovereignty, I would submit for your consideration also the fact that, for instance, in the case of CISG, well, Article 7 is a treaty obligation for any contracting state. Of course, we could discuss from a constitutional law point of view to what extent that treaty obligation has effect in each jurisdiction, but I believe that judicial sovereignty would not be able to go beyond such a treaty obligation of their state. And to a certain extent, maybe there is a duty of uniform interpretation and also a positive obligation to take into consideration cases from other jurisdictions that enable that uniform interpretation, but also probably a negative obligation to not challenge in a way that is not sufficiently grounded the established uniform interpretation of certain clauses. But this is just food for thought, if you wish. And finally, the question from Justice Huang. Yes, indeed. So we don't have many cases of jurisdictions that have implemented the principles. We have Paraguay, which is the most well-known. We hope with the coming publication of Professor Ginsberg to have a better sense of what's going on around the world. But the case of Uruguay is very important, and as you rightly asked, in what ways did they depart or complemented the principles? They, of course, filled a gap. They introduced Article 11 in their law that addresses the absence or inefficiency of the choice of law made by the parties, and introduces, of course, the relevance of the law with the closest ties with the contract and the parties. So that would be, of course, the primary difference. And I would conclude with an example also that links to the first question from Judge Lee. It's the case of Mozambique. So Mozambique is currently undergoing a full-fledged reform of their commercial code and their law of contracts, supported by the World Bank. And the HECH has worked closely, including drafting of several provisions of that reform. And in particular, there is a section in this new law on commercial contracts that basically reproduces, copy-pastes with minor adaptations of drafting nature, the HECH principles. So it will be probably the first case of full incorporation of the principles, and it will highlight the importance of the principles, especially in transitioning economies. I hope I have addressed all the questions, but I will be happy to revisit if the chair wishes so. Thank you very much. It's really nice to be connected to Seoul again. Thank you.
Thank you. Thank you, Dr. Ribeiro Bidawi, for your valuable answers and observations. Now we are wrapping up the session 1 and moving to the session 2. The first panelist we have Judge Min-jun Park from Seoul Bankruptcy Court. Judge Park, please go ahead.
Yes, thank you very much for the introduction, Chair. I'm Min-jun Park, a judge of the Seoul Bankruptcy Court. I'm really honored to participate in this meaningful and interesting section. Actually, this opportunity where I could ask some questions directly to distinguished experts is truly invaluable. I'm going to focus my discussion to the Cape Town Convention and the Aircraft Protocol. However, some of my questions would be related to insolvency. By the way, the content of my discussion starts from page 128 of the program book. The first question I want to ask is, what's the possible impact of COVID-19 crisis on expansion of the Convention and Aircraft Protocol? As Professor Tirado mentioned earlier, the Convention and Aircraft Protocol has been really successful. Many countries became contracting states. Although Korea is not a contracting state yet, I want to point out that it seems many professors and practitioners are interested in the Convention and its protocols. But due to the current health crisis, the entire airline industry was hit hard by the crisis, and many airline companies already filed for insolvency procedure. Therefore, there could be some cases where holders of international interest actually take possession or control of related aircraft objects pursuant to the Convention and Aircraft Protocol after the event of default. I'm afraid that after witnessing the real power of remedies for international interest holders when there are defaults, some countries which has yet to adopt the Convention and Aircraft Protocol might hesitate the adoption more than before. Meanwhile, among many current and subsequent insolvency proceedings, if there are some occasions where the enforcing mechanism under the Convention and Aircraft Protocol is disturbed due to the contracting state's domestic law or its interpretation, then it might have negative impact on the sustainability of the discount based on the adoption of the Convention and Aircraft Protocol with qualifying declarations. So I wonder how the COVID-19 crisis would impact the future expansion and development of the Convention and Aircraft Protocol. My second question is on page 131. A creditor who has an international interest in an aircraft object may exercise remedies in the event of the debtor's default without leave of the court, though is subject to relevant declaration. And such remedies shall be exercised in a commercially reasonable manner. Especially given the huge size of aircraft objects, my second question is, what's the established practice of exercising remedies in a commercially reasonable manner, if any, with regard to aircraft objects? My third question is related to the treatment of international interest holders in insolvency proceeding, and it's from the page 132. Insolvency law usually divides creditors into several categories, like the division of secured creditors and unsecured creditors. In many insolvency proceedings, not only unsecured creditors, but also secured creditors are bound by the insolvency proceedings, thus cannot enforce their rights outside the insolvency proceeding. Meanwhile, under the Convention and Aircraft Protocol, holders of international interest on aircraft objects can take possession or control of such objects, even though the debtor filed insolvency procedure. Therefore, holders of international interest should be treated differently than other secured creditors in an insolvency procedure. but I wonder what is the extent of different treatment, particularly in terms of voting rights on the plan or bifurcation and the likes. My first question is on page 134. Is about deciding the debtor's primary insolvency jurisdiction. Insolvency provision, namely Aircraft Protocol Article 11, is applicable only where a contracting state, that is, the primary insolvency jurisdiction, has made a declaration adopting the provision. Therefore, it is important to decide where is the primary insolvency jurisdiction of the debtor. Then, who would actually decide the primary insolvency jurisdiction? My understanding is that maybe court of a country where the debtor's aircraft is located ends up deciding whether the country of the debtor's insolvency proceeding is the primary insolvency jurisdiction or not. Particularly, it seems the court of a country where the debtor's aircraft is located can decide the debtor's center of main interest, by recognizing the debtor's insolvency proceeding as main proceeding if the foreign representative applied for the recognition of the insolvency proceeding. Since it seems the definition of primary insolvency jurisdiction in the Aircraft Protocol was inspired by the concept of coming in the model law on cross-border insolvency, the court of a country where the debtor's aircraft is located can effectively decide the primary insolvency jurisdiction of the debtor by recognizing the debtor's insolvency proceeding as main proceeding. Meanwhile, there could be countries like Korea who do not distinguish main proceeding and non-main proceeding when it comes to recognition of foreign insolvency proceeding, even though they adopted the model law. Thus, even if such a country recognized the insolvency proceeding of the debtor, it would be hard to tell which country is the debtor's primary insolvency jurisdiction. In such a circumstance, if the foreign representative of the debtor views a country which adopted Alternative A of Article 11 as the debtor's primary insolvency jurisdiction, then the foreign representative shall give possession of the aircraft object to the creditor pursuant to Alternative A. In that situation, the foreign representative, as opposed to the court, effectively decide the debtor's primary insolvency jurisdiction. I wonder whether that would be appropriate or not. My last question is on the page 137. It's mainly about the coherent interpretation of primary insolvency jurisdiction among countries. There are some cases that airline company based on one country filed insolvency proceeding in another country. If the country of insolvency proceeding views the airline company's primary insolvency jurisdiction is itself, since the country allows rebutting presumption of primary insolvency jurisdiction more easily, it would be a lot difficult for the creditor to take possession of the aircraft. So I wonder if there are some possible ways for coherent interpretation of primary insolvency jurisdiction. That's the end of my discussion. And finally, I want to thank Professor Tirado for sharing knowledge and insight with regard to the convention. Thank you very much.
Thank you. Thank you, Judge Park, for your comments and questions. He is working in the bankruptcy court, and he is in the best position to raise all these insolvency-related issues. Our next panelist, Judge Juyeon Lee from Suwon District Court. Are you ready? Yeah. Please go ahead.
Thank you, Chair. It's an honor for me to be here with distinguished speakers and participants. Let me present you some additional issues briefly. I think one of the most universal and significant issues of these days is the COVID-19 pandemic. The pandemic and the following lockdown have led to a massive economic crisis throughout the world. Many governments, legislative bodies, and courts provide procedural and substantive methods of relief to debtors in general civil matters, including insolvency. Meanwhile, courts face an increase of insolvency cases. I'll show you some examples of emergency measures taken by several states. About insolvency proceedings, some states suspend the debtor's duty or the creditor's right to file for insolvency. Moratorium on the performance of established reorganization plans and amendment of the plans are allowed in some cases. Procedural time limits in insolvency proceedings are extended in some states. About general civil matters, some states suspend the enforcement of judgments or the payment of debt installments. Also, the contract termination or the imposition of penalties and interest due to default are suspended in some states. These measures may lead to an increase of cases requiring judicial judgments, but in many states, judicial function has been partially suspended. A delay in hearings is an example. The forms of these emergency measures vary from state to state. Some measures are in the form of legislative changes. Others are in the form of orders or recommendations of administrative authorities. There may also be some practical operation of judges. As Professor Tirado pointed out, some aspects of the pandemic and the emergency measures may act as negative factors to cross-border insolvency. Due to restrictions on cross-border movement, it's difficult for foreign representatives or foreign creditors to have physical access to insolvency proceedings in other states. The diversity of emergency measures in contents and forms may make it hard to get information and predictability on insolvency proceedings in other states. I wanted to ask a few questions to Professor Wisitsora-Ed, but I guess he's not present, so I'll skip my question. Instead, I want to make a comment on his presentation. UNCITRAL has worked for a long time to promote legal certainty, universality, and communication between states by providing excellent legal frames to them. The contents about access and cooperation in UNCITRAL model law on cross-border insolvency are very useful to alleviate the above-mentioned hindering factors in cross-border insolvency in this crisis, I think. And I'd like to add one more issue about secure transactions in Korea. As Professor Wisitsora-Ed showed us in his presentation, the availability of credit using various types of assets is essential, especially for micro, small, medium-sized enterprises. In Korea, there had not been an integrated and comprehensive law covering all types of movable assets. A few years ago, the Act on Security over Movable Property, Receivable, and Others entered into force. That the Act coexists with assignments for security purposes, which have been developed by court precedents for a long time. Therefore, there still exists the risk that a creditor will not be guaranteed third-party effectiveness or priority, even though the creditor made the security right in trust of the registration under the Act. And the principal method of enforcement under the Act is public auction, and the principal method of the public auction is on-site auction. It may make the recovery smaller and take a longer time than a private sale, which is also available online. I think these are some of the factors that hamper the active use of security over movable assets. My question to speakers is here, but I better skip it to meet the allocated time. And Professor Tirado already gave us valuable advice on promoting legal certainty. I deeply agree to his remark that more certainty leads to less risks and lower costs. I think it is necessary to refer to UNCITRAL model law on secure transactions and Cape Town Convention and its protocols to establish a clear and comprehensive rule over various types of movable assets in Korea. Thank you for your attention.
Thank you. Thank you. Thank you, Judge Lee, for your apt and practical comments and questions in this field. And I have to inform you that our speaker from the second session, Professor Wistroet, is an unavoidable situation where he cannot speak in the discussion. So he excused himself. So we have only one speaker, Professor Ignacio Tirado. Are you there? Oh, thank you. Thank you. You have the floor. Go ahead.
Thank you, Judge Yoon. Thank you very much. I would like to sincerely thank Mr. Park and Ms. Lee Judge Park and Judge Lee for their excellent comments and interventions. Thank you very much for them. Since old friend Wisit Witsora and co-panelist is not here, I will not, of course, try to address the many reflections conveyed or shared for him. I would, however, like to, if I'm allowed by the moderator, to start by addressing the last question on the model law on secure transactions, which was, or the comment which was posed before I go into the detail of the Cape Town Convention. Of course, what I'm going to say is not in my capacity as Secretary General of UNIDROIT, so I take off that hat and with the permission of my colleagues from UNCITRAL, I will just make a brief reflection as a former member of the working group 6 that drafted the model law on secure transactions, and I was then representing Spain. I worked there for many years and I keep very fond memories. I am a big believer in the UNCITRAL model law on secure transactions, which represents best practice internationally, and it is very much advisable that countries would consider incorporating their tenets, and if not the model law itself, to their systems. The system is a system which is extremely functional, which is very flexible, and which allows for a clear system of priorities, a clear system of registration, and lowers substantially the cost of registration, of creating a security right which is enforceable vis-a-vis third parties. And because secure transactions over movable assets very often concern low-value assets, it is extremely important that the system is efficient and has low cost. That is why many countries who don't have the model law type of system don't use security right over movables. They don't do it because being the amounts to be guaranteed very low and having to undergo a very formal system of security rights, as is the old traditional civil law system, the same in Europe, in many civil law countries in Europe, at least until the recent wave of the reforms, that makes it not useful to them because it's going through too much trouble for too little. So the implementation of the model law, it is now proven that creates and enhances substantially the use of security rights over movable assets. And we have to remember that it is not infrequent that small companies and small businesses, and especially the smallest, the micro businesses, do not own land to use as collateral. All they own are movable assets, including receivables. So if you create a system that allows these small debtors to use all their assets, small as they might be, in an efficient manner, they will access credit. And if they access credit, the economy will thrive. So I would very much encourage the use of the secure transaction model law by UNCITRAL. Your last comment was referred to enforcement. The model law stops short of providing a comprehensive set of rules to enforce security rights, because enforcement goes very deep into public law and the public interest principles of every country. It's very national. So apart from making statements as to the need to have an expedient and effective enforcement mechanism and providing a few basic rules, it does not go into the detail. So it would be up to the different domestic legislations to ensure that the model law is complemented with a comprehensive and efficient system of enforcement. Enforcement which out of court, of course, is also something which should be considered. Having said that, I will try to focus on Cape Town, being brief, of course, and answer at least some of the many excellent questions and remarks posed by Judge Park. And I apologize, I have a little bit of a fish memory, as we say in Spanish. It's not a very long-term memory, and I apologize if I forget to answer one or two of those. I hope not. So the first question, which is, I believe, more a reflection, as I take it, was seeing that, on the one hand, many airlines are going into insolvency these days, which is absolutely true. It is one of the most affected industries in the world. Of course, traveling has become very difficult, and therefore the airlines are suffering extremely from this situation. Being many airlines in insolvency and having Cape Town a very strong system of protection for creditors' rights, wouldn't that be something which would lead countries to hesitate to adopt Cape Town? My opinion is that it's actually the opposite, because what Cape Town is doing is proving that even when it is put to the test, it works. It works to protect creditors, which is the main function of the system. And therefore, going forward, it would even be stronger, and countries will want to join it more, because it has proven that even under the hardest of circumstances, the parties can trust what's there in the treaty. And, but worry not, the fact that Cape Town Convention empowers creditors to ensure that they can be repaid with the asset, they can repossess the asset or realize its right in any of the remedies that, based on any of the remedies that are provided for in the convention, doesn't mean that they do it. It means that they can do it. But creditors in the aircraft world are sophisticated creditors, and they know very well that it is in their own interest, in case the airline is viable, to ensure that the business of the airline continues. And creditors very often do not have any interest in repossessing the aircraft. What it does is just provide creditors with a strong bargaining power. They are protected by the convention. And because they are protected, they feel strong and capable of negotiating with the debtor an agreement which will help the debtor. Because if it helps the debtor, it will help creditors too. Because creditors with airlines are repeat players. Manufacturers of aircrafts, Boeing, Airbus, and Bombardier, and all the big companies, they are interested in the survival of airlines. Financiers that finance the acquisition and the lease of aircrafts are interested in the survival of airlines. There is no interest in them to sink an airline. On the contrary, it is good for them to know that they can repossess if they want, because that is what the parties agreed to freely. But on the other hand, they will only do it if it is necessary and it's in the interest of both parties because the airline is no longer viable. In other words, the treaty is going to get out of this crisis stronger, and this is going to create a level playing field for renegotiation in insolvency proceedings, which is going to be very useful for countries, and I'm sure they're going to realize this. You also made reference, I have my notes here, the impact on the discount. So far, I would encourage you to have a look at the annotations to the Cape Town Convention official commentary, which is open for public in the openly accessible in the Cape Town Convention Academic Project website, which can be also accessed through the UNITRA website. And there you have an explanation and update on the situation. But so far, there is no removal of the discount by the OECD because precisely the treaty works. And because the treaty works, there is no reason to remove the discount. So these questions were related. Another question concerned, if I understand correctly, the interpretation of commercial reasonableness in enforcement. Well, you have to think here that commercial reasonableness, which is, clearly a very common law type of general concept, is a very open one. However, in the area of Cape Town, it is not so open. What matters in Cape Town is what the parties agreed to. And this is based on the fact that the parties to an aircraft agreement, for example, are both sophisticated parties. It's airline negotiating with a financier, an airline negotiating with a manufacturer of aircrafts. They're both big, sophisticated companies, and they can freely, without any imposition, agree to certain remedies. And if those remedies are included in the financing contract under Cape Town, there is absolutely no reason why they should not be enforced. Only if the debtor can prove that is commercially unreasonable that enforcement takes place, that perhaps a defense can arise in court. But it's not that the creditor needs to prove commercial reasonableness of enforcement because that's what the parties agreed. It's the other way around. It switches the onus of proof and puts the burden on the debtor who should prove the clear unreasonableness of the enforcement mechanism. Another question or remark concerned the treatment of Cape Town creditors in insolvency, and you mentioned the Korean law, insolvency law. Well, most certainly, a Cape Town creditor will be a secure creditor and will be treated at least in that domestic law as a secure creditor is treated in insolvency. Normally, I don't know Korean insolvency law, unfortunately, but normally in insolvency laws, secure creditors are given a vote in a reorganization scheme to the extent that they are affected by the reorganization scheme. The expression used internationally is impaired creditors. They are impaired, therefore, if the plan proposes to change their rights, then they should get a vote, be that Cape Town or not. In the case of Cape Town, however, it is unlikely that a Cape Town creditor will be affected by a reorganization scheme unless it decides that it's in its interest to participate in the reorganization scheme, because the treaty protects this creditor. As I said before, the Cape Town creditor will normally be happy to participate in the reorganization so long as that makes commercial sense, because it allows for the viability of the creditor, of the debtor, of the airline, and that is something which is in the interest of the creditor too. And finally, reference to the primary insolvency jurisdiction. As you very well mentioned, a primary insolvency jurisdiction is the concept that is used in the Cape Town Convention, which is very similar to what the model law calls main insolvency proceedings. All of these are concepts from the ancestral model law, which originally came from a failed European insolvency statute, which was never approved, but that's what informed the process of drafting of the ancestral model law on cross-border insolvency. That obviously also influenced the Cape Town terminology. The primary insolvency jurisdiction is the jurisdiction of the COMI. Allow me to read to you the aircraft protocol, where it says primary insolvency jurisdiction means the contracting state in which the center of the debtor's main interest is situated, and then provides for the usual presumptions of domicile, etc. So I don't really see an issue with where the primary insolvency jurisdiction is situated. It will be situated wherever the COMI is, and that will need to be ascertained in the moment in which the debtor becomes insolvent. So when a company becomes insolvent, that will constitute an insolvency-related event, and therefore it will be up to the court to decide in that very moment where the center of main interest is, and therefore where the primary insolvency jurisdiction is located. You provided an example which is very interesting. If I understood correctly, we are talking about an airline company whose place of statutory seat is in state A, filed for insolvency to a court of state B. State A is an aircraft Cape Town country which opted for alternative A of Article 11. State B is a Cape Town country which did not opt for Article 11. And after the petition, the airline company's creditor, who has an international interest in an aircraft, wants to take possession of the aircraft. But the aircraft is in state B. What happens then? Well, this example you've just provided is actually a real case example, which is happening very often now these days with a number of airlines in the United States, for example. Airlines from South American countries, even from Asian countries, have filed for Chapter 11 cases in the United States, while, and notwithstanding the fact that the COMI is elsewhere, it's in their countries of origin and operation. So the question would be, where is the primary insolvency jurisdiction? The primary insolvency jurisdiction is in the country of COMI, not in the United States, wherever else it is. That's where the primary insolvency jurisdiction is. And that means that even in the United States, because of Article 34 of the Convention, the insolvency option chosen by the country of the primary insolvency jurisdiction applies. So the American court would need to apply the foreign law as determined by the Convention. I got a little bit too technical on this, but I think I addressed most of your questions. I apologize for the long intervention, and I remain at your disposal. Thank you.
Thank you. Thank you, Professor Tirado, for the well-thought and well-prepared answers. I'm very sorry that we are out of time schedule. I cannot keep my words, and we are well behind. I feel especially sorry for our staff and interpreters. I'll try my best to expedite. As I said, we have only 5 to 7 minutes, but still it shows 10 minutes. Okay, now we are moving to session 3, and our next panelist will be Professor Kyu-ho Lee from Chungang University School of Law. Yes, Professor Lee, please go ahead.
Thanks, Chair. Hunger and fatigue start to dominate my brain, so I speed up my discussions. So I'm happy to be here as a panelist, as an extra for the third session. The permanent anti-suit injunctions can be categorized as a final judgment defined under the Convention on Choice of Court Agreement, where an anti-suit injunction to uphold an exclusive choice of court clause is a measure to make the choice of court agreement more effective, the anti-suit injunction will be likely to be granted before the courts in common law countries. However, in civil law countries, anti-suit injunctions to uphold an exclusive choice of court agreement are not available. In this context, I'm wondering whether common law countries are in better positions to adopt and enforce the Hague Choice of Court conventions. This question is addressed to Justice Goddard. It should be noted Singapore has adopted Hague Choice of Court Convention in 2016. I'm guessing in 2018 is the first case in Singapore where the domestic law implementing the Hague Choice of Court Convention is applied to an international case. Let's move on to the second the subject. According to the information shown in the UNIDROIT homepage website, ALI Annual Conference and General Assembly were held in 2018 to discuss collective redress, and allied UNIDROIT project on transnational civil procedure, formation of regional rules, was presented at a conference held on November 26 to 27, 2018, 3 years, to address key project issue parties, collective redress and funding, civil procedure, the challenges of modern technology and artificial intelligence, and structure of civil proceedings toward a coherent model law. I'm aware that Professor Veneziano is one of the key figures of that project. Hence, I'm very much honored to have the chance to ask these questions. The COVID-19 pandemic is affecting current evidence gathering mechanisms and service process, as well as collective redress on basis of cutting edge technology such as AI and blockchain technology. For example, the ambulance chasers familiar with the cutting edge technology can draw the attention from the potential clients and in pandemic era. So I'm just doubting the traditional collective redress, such as the class action and the organization the suit, is the effective and the efficient in this matter. So the technical development in the hyper-connected society, the pandemic, can make a class action and organization suit more effective. My inquiry is how the current pandemic can affect your project in the future. This question is addressed to Professor Veneziano. The last question is addressed to the Judge Chang. And as the Justice Goddard mentioned before, the scope of the Hague Judgment Convention is not applied to the IP matters due to the fact that it requires more time and works. So taking into account the importance of the intellectual property, its scope should be extended to intellectual property. Could you share your opinion with us in terms of these issues? So I stop here. Thank you.
Thank you. Thank you, Professor Lee. Thank you for your very interesting and practical questions and comments. Now, our last panelist, Judge Yoon-jong Kim. Please go ahead.
Unfortunately or fortunately, time is running out. So I will skip over many parts.
Good afternoon and good morning, everybody. And thank you for having me here. And I'm really grateful for the privilege to participate in this exceptional conference. Before we go any further, I would like to express my gratitude to distinguished chair and the speakers for the fascinating presentations. I would like to make a couple of comments on the two beautiful Hague conventions and one question UNIDROIT's startup projects, so-called best practice of effectiveness in enforcement. I would like to start with my personal experience as a former secondee at the PB of Hague conference. It is very delightful to witness the gradual progression and the significant outcome in the judgment project. Okay. As you can see on screen, there have been very intensive and extensive discussions and analysis regarding the necessity and the benefits to joining the convention in Korea. I can't stress more that how essential and timely to sign up the convention, not only for Korean judiciary and the legislative branch, also for economic development and international relations. This point leads us to my next comment, which shows the noticeable influence of the choice of court convention on our domestic law. In November 2018, the whole revision draft of international law of Korea was filed with the cabinet meeting, which newly embodied specific rules of international jurisdiction. As you can see, the specific provision, Article 8 of the draft, provides the so-called jurisdiction clause shall be presumed to be exclusive. It deserves attention because the Supreme Court of Korea has interpreted the exclusive choice of court agreements with very strict standards. According to the Korean court's decision, it requires the reasonable relevance between the case and the designated courts. Given the legal stability and the predictability, exclusive agreement provision of the convention laid the groundwork for effectiveness of parties' choice of court agreements. Furthermore, regarding the grounds of invalidation of the agreement, the draft tracks the equivalent of the convention. Let's move on to judgment convention. Luckily, Korean Supreme Court has shown very favorable attitude to recognizing or enforcing foreign judgments. In addition, the obvious conclusion of many related symposiums and seminars on this new convention, there are strong endorsements from academic and practical experts and professions. Among diverse issues on the whole framework and the individual provisions of the convention in this conference, I would like to point out notification issues, because I'm addressing the related matter with the possibility to change the judicial precedents with a case study in the Supreme Court now. The convention set out grounds of refusal of the recognition and enforcement in Article 7. One of the grounds is a lack of proper notification to the dependents. As to appropriate notification, which is very critical for due process, the provision clarifies the documents should be served in timely manner, but it seems a bit ambiguous whether the service should be performed in lawful method or not. In addition, the provision does not require personal service on the dependent, and also other methods of service may be allowed. However, some courts, such as Korean court, consider public service as invalid because this type of service might violate to dependents' right to be heard. According to the subparagraph A2 of Article 7, the notification should be carried out in a manner that is compatible with fundamental principles of the requested states. I feel like the adequacy of notice should be further researched and analyzed with practical case study for stable standard setting between member states. Anyway, I believe that these conventions, combining with the Hague Conference new jurisdiction project, are able to break new ground for common framework for recognition and enforcement of foreign judgment. Let's move on. Another part of the presentation carried by Professor Anna Veneziano. First of all, I'm very impressed with the backgrounds and the evolution of UNIDROIT's work on transitional civil procedure, which have crystallized into Ali UNIDROIT principles and Ali UNIDROIT model law. In particular, I'm very overwhelmed by the detailed analysis and intensive coverage of Ali UNIDROIT model law rules, and looking forward to its far-reaching influence on legislation across the world. Let's talk about the effective enforcement mechanisms. Among many challengeable issues, I would like to ask about the scope of the project. According to the documents on the website of UNIDROIT, the insolvency-related enforcement is included under the scope of the project. If my understanding is correct, the reason is that is to ensure creditors' satisfactions and the consistency of the mechanisms. However, besides the work in UNCITRAL, there is a wide spectrum of domestic regulation and systems with very different jurisdictions. But the more insolvency procedure itself is profoundly different from general civil procedure. Considering this exceptional situation, I'm wondering whether it is practically efficient and desirable on behalf of creditors. With this question to Professor Anna Veneziano, I will shall wrap up my comments. Thank you for your attention.
Thank you. Thank you, Judge Kim, for your insightful overview of these major issues. Now we have our speakers for our third session. Justice Godard, are you there? Thank you. Thank you very much. Please go ahead.
I'll be brief because it is getting late at night here. It's after 10 o'clock. Professor Lee, there was a fascinating question about the implications of anti-suit injunctions and whether the willingness of many common law states to grant those would make the choice of court convention more appealing to them. I don't actually think it should make a difference because the issue arises, of course, only if the state in which one party wants the proceedings to be heard has been chosen under an exclusive choice of court agreement and is a contracting state, and another state the courts of that state are considering whether to entertain a claim by another party, even though it's not a chosen court. The convention will only be relevant in that second state if it's also a contracting state. But in those circumstances, the choice of court convention already requires the non-chosen court to decline jurisdiction. It's a very absolute rule with almost no exceptions. So it seems to me that the question of an anti-suit injunction granted by the chosen court becomes rather academic because if the dispute is within the scope of the exclusive choice of court agreement, the court where a party is sought to be restrained from suing will in any event decline jurisdiction. So I don't think, I can't imagine a situation in which an anti-suit injunction would become relevant, would make a difference, So it shouldn't mean that the convention is more attractive to states willing to grant such orders than to states that do not. I did begin to wonder whether more difficult issues could arise in relation to the Judgments Convention and non-exclusive agreements with a prorogation component. For example, agreement that disputes will be resolved in the courts of State A or State B, but no other courts, which is not exclusive as defined in choice of court. If a court in State A granted an injunction restraining a party from suing in State C, might that be enforced? I think there would be interesting questions about whether in State C, if it was considered that there was a sufficiently compelling reason to hear the case notwithstanding the prorogation, there might not be public policy reasons for declining to enforce a final anti-suit injunction. But I would need more time to think that through. It really is a very interesting question. Judge Kim, first of all, can I just endorse your observations about the benefits for states of becoming party to the Choice of Court Convention? I agree completely. Your comments were music to my ears. I think the instrument is very valuable for businesses based in a state that becomes a contracting state because of the significant impact the instrument should have in terms of reducing risk, reducing uncertainty, the same benefits discussed in a different context by our colleague, the Secretary General from UNIDROIT. So I think in Korea and in New Zealand and in other potential contracting states, it's very important to ensure that those benefits are understood and that we do what we can to encourage early accession to that instrument. The Judgments Convention, because of the late hour and because we're running over time, I won't get into too much detail about the notification issues, but you asked, Judge, about the Article 7 provision, which permits recognition or enforcement to be refused if the document first was not notified to the defendant in sufficient time and in such a way as to enable them to arrange for their defence. That is intended to be a factual inquiry. It doesn't require compliance with the legal rules of the requested state. Rather, the focus is very much on the practical question of whether the notification was adequate. A requested state cannot say, well, service, although it took place in the requested state, breached our local rules on service, so 1A1 applies. But there are some states, and Japan is a well-known example, and I believe, actually I can't remember the position in Korea, so I won't guess. The room is full of people who know this better than I do. But there are states that consider that their rules in relation to service of documents in that state raise fundamental questions. That there are fundamental requirements that must be complied with, failing which a judgment ought not to be enforced. And that's what 7.1a.2 is about. If a document was notified to the defendant in the requested state in a manner that's incompatible with fundamental principles of the requested state concerning service of documents, then recognition or enforcement can be declined. And ultimately, it's up to each contracting state in its capacity as a requested state to decide which, if any, of its principles relating to service should be seen as so fundamental that they justify refusal of recognition or enforcement. The provision is a safety valve for states that see rules about service in that way, and it enables them to determine which of their principles are sufficiently fundamental to justify that response. So ultimately, for Korea, for example, it will be your call as to which, if any, of your service principles are so fundamental that non-compliance with them should mean that a judgment would which had its origins and service in that manner will not be enforced. I hope that helps with that, and I'll stop there, I think.
Okay. Thank you, Justice Godard, for your valuable last observations and your patience and wait. Our next speaker, Professor Veneziano. Thank you very much. Thank you very much. Go ahead.
Thank you very much, Chair. And thank you very much indeed to Professor Lee and Judge Kim for their comments and the excellent and also difficult questions. So I'm aware of the time and of the pending dinner for you, so I will try to address only a couple of them and happy to engage in further discussions in a different way. So the question of technology, COVID-19, and procedural rules. As Professor Lee said, there were discussions in the project, ELI-UNIDROIT project, even before the present emergency, on the appropriateness of the use of modern communications, recording means, electronic communication between courts and parties, between parties, video conferencing, audio transmission in hearings, evidence taking, disclosure and production of electronic data and documents, evidentiary evaluation of them, as well as the reference to the possibility of use of electronic platforms, for example, in collective proceedings. And these issues are referred to in the adopted rules, but especially in the comments accompanying them. The rules, however, as a choice of the group, wanted to be technologically neutral and therefore do not address the issues in detail, given the different levels of technological development and use in the different legal systems, but also the fear that any reference to specific technology may become quickly obsolete. So there is scope, of course, for further research and discussion, which is most useful, I think, at a global level and not just at a regional level. And the impact of COVID-19 highlights the importance of technology as a solution to in-presence participation. But I understand from Professor Lee's question that we also need to address the challenges. Now, some of them are not really legal challenges, for example, access to technology. Others are linked to the possibility to exploit information, data protection, but to address issues that might be more linked to the scope of the private law work of UNIDROIT, I really believe that technology can be a solution to enhance efficiency and transparency also in these proceedings. But there are difficult questions to address. For example, does it make a difference if these mechanisms are dealt with by a public authority, a private entity? How can we ensure that there is a reasonable protection for parties when automatic systems of enforcement apply? So those are questions that we will try to address, at least in the new project of enforcement, which brings me to the question posed by Judge Kim on the scope of this work in progress. I would like to underline that this is a work in progress, so the scope is in the hands of the working group. We discussed, however, the issue of including enforcement in insolvency at length, and so the result was that to exclude insolvency would be sending a very wrong message because of the importance for creditors of enforcing in insolvency, but the project would not address the specific issues covered by insolvency legislation, just to make one example, whether there is a moratorium or not, but it may address mechanisms used in individual enforcement that can be used also in insolvency. And also we would and we will work in a very strict coordination with the other intergovernmental organizations, and particularly UNCITRAL, the World Bank, and others, in order to ensure that there is no overlap and that the work is smoothly developed. So I hope that this answers at least some of the questions, and I know that this is a beginning and not the end of discussions on this. So thank you very much for your patience, even if we are running a bit late. Thank you again, Chair, for giving me the floor.
Thank you. Thank you, Professor Veneziano. Now we have our last speaker, Judge Jang Ji-yong. Are you ready? And you have all the time remained.
Thank you, Chair. I'm going to answer to the questions from Professor Lee. I fully agree with your idea, and in light of the importance of IP matters to global market, the convention, it would be better if the convention extends to the intellectual property matters. But unfortunately, the consensus was not reached at the special commission last year. And yeah, but especially for Korea, we have established an international panel at the Patent Court and at the Central District Court. So I do hope someday we have a convention which applies to the IP matters, and before that, the judgment convention enter into force first. Thank you. Thank you for having me.
Thank you. Thank you very much. For your information, we have questions raised from the floor, which number is none. So there will be no further questions. And as you all see, we have so many interesting and important issues covered. Still, some of them are not answered. So we recommend to discuss those issues during the dinner, and I will complete our discussion session here. Thank you for the staff and interpreters. Thank you very much.
Thank you very much. We had very inspirational and thought-provoking discussions. We have come to the closing of today's conference. On behalf of JPRI, I would like to express my special appreciation to all of the moderators, speakers, and panelists for your valuable contributions to our conference. Thanks to today's presentation and discussions, I'm sure that our knowledge and understanding of international commercial litigation has been broadened and deepened. Hope you have a good evening, and I'll see you at 12 p.m. tomorrow. Thank you.